reply. Any record may be called for. The IIT student matters, urgent matter, your lordship.
Okay.
Matter may be taken up at 2 p.m. Your lordship.
That we'll see.
It is very urgent matter. Yes. In 30th, it will be matter will be infectious if 30th July. If
Lordship, this matter may be after taken motion because four matters already infectious. They have accepted. They have already
we have no instruction
submitted,
this kind.
submitted the
Without
undertaking.
instruction, how do you say it's urgent?
We have no
Four
instruction
matters.
regarding admitting anything.
Four students already they have admitted and they have already undertaken lordship. Why this is urgent? Because from 24th or 25th the classes will be going on. So we need the direction because they have already given undertaking. So direction to comply the other proceeding because that four students maybe continue with their studies.
Okay.
After motion maybe lordship.
After motion, it will be difficult for us.
Why?
For other matters are there.
I don't understand. You say it's urgent. You want it at 2 o'clock. After motion, you want we're trying to have it. You saying you're
And 2 p.m. it is
you will okay.
Well, for listing of one leave petition, well, it was last listed on 5/9/2022.
5?
5/9/2022.
Okay. Second, August.
Lordship, one matter that is regarding equalization of pay, Lordship. And in the
Regularization of?
equalization of pay, yes,
Yeah.
Lordship, my petitioner is going to retirement. That is a matter may be listed on Monday, that is on 29th. Lordship.
My pleasure, Lordship. Lordship, it's a prayer for listing, my lord. It's a contempt matter pending for last year. Maybe on Wednesday, if possible, my lord.
With many cases are there. We'll have it on Friday.
Friday. That's obligatory.
Lordship, I have also prayer for listing a contempt matter of 2022. May I say Friday?
Lord, with consent of the respondents, I pray for an adjournment for today, your lordship, in item number 71.
Item 71.
Lordship.
You are appearing for your good name?
S. Day, your lordship. I am appearing on behalf of Mr. S. Bothakot.
Okay, on request made on behalf of Mr. S. Water. When do you want?
Lordship, just pass over for the day, your lordship.
Least after 1 week.
Please, your lordship. My lord, item number 87, my lord. It was listed on Friday, last Friday, my lord.
Oh,
And due to urgent nature of the matter, your lordship fixed it today, my lord. And there was an also prayer for upgrading the matter on the last occasion. Your lordship is allowed, my lord. So it may come up at 2, my lord.
at 2, I've already fixed one matter.
After that matter, my lord.
Yeah.
Maybe. Obliged.
May it please, your lordship, with the consent of the other side, I beg to mention item number 74, 75, 76. We'll require to file a rejoinder affidavit.
Okay. Your good name?
R. Sinha.
On request made by Arsenal and the company for the petitioner. Is the matter when how much time you will
For 2 weeks, 3 weeks, your lordship.
after 3 weeks?
May I please, your lordship? I beg to mention item number 73 with consent of others at lord. Possible for the day.
You're appearing for
Petitioner,
your good name?
RL Sutia.
On request made by RLCPL and council for petition.
I am for the respondent number 3.
List the matter after 1 week.
Matter will fix on Friday, Lordship. I am for the respondent number 3 in this 73.
So why do you want on Friday?
Lordship, the college is suffering.
Okay, Monday. List the matter. So
May it please your lordship.
Monday is what? 29.
May it please your lordship. I beg to mention item number 21. Lordship, in this case, we have filed 2 additional affidavit, lordship. That may be called for lordships.
Item 21.
Yes, lordships.
That goes with item. It's a long list.
Lordships. We have filed 2 additional, that may be called for your lordships.
Up to item 61. Infringement of parties. Okay.
DP of lordship.
May I please, your lordship, prayer for listing. The matter pertains to non-payment of retirement benefits.
Okay. 31st.
May please, your lordship. Lordship, I beg to mention for listing of a matter for admission, lordship.
Second.
Obliged, lordship.
Lordship, I beg to agenda matter item number 70, Lordship. Lordship, today is fixed for filing of affidavit in reply to the affidavit in opposition filed by respondent number 2 and 4. And today itself, Lordship, the petitioner have filed the same, Lordship.
Hmm.
So kindly tag it along with the writ petition, Lordship. Today itself, Lordship, we have filed the affidavit in reply to the affidavit in opposition filed by respondent number 2 and 4, Lordship.
Oh,
Therefore, I beg to pray for agenda matter for the day, Lordship.
you want an adjournment?
Yes, Lordship.
Your good name.
D. Burman, Lordship.
On request made by D. Barman and a counsel for petitioner, list the matter when, after 1 week? Yes.
Deeply obliged, Lordship.
Your lordship. Lordship, I beg to adjourn item number 89 and 90 for the day, as my senior is on leave, lordship.
80?
89 and 90.
Oh, that goes with 88.
Yes, lordship.
Who's your senior?
P. Mohanto. A leave application is already been given, lordship.
And how about 88?
I could not.
Just a problem, no? Okay, on request made on behalf of Mr. P. Mahanda, learned counsel appearing for the petition in WBC 3782 of 2022. List these matters when?
After 1 week,
After a week. Okay.
much obliged.
Lordship, I beg to mention for listing of a writ petition, Lordship, in admission.
Okay. Fifth August.
May I please, your lordship? Also, I beg to mention for listing of contempt with the lordship, please to notice, notice was issued by lordship, 22/5 lordship, making it returnable 6/6 lordship. It has not been listed, lordship.
Okay.
Lordship, may I pray for lordship on Friday if possible, lordship, because
Friday, many cases are fixed. 29, Monday.
deeply obliged, deeply.
Item 62 of daily list. Patient.
Only W is supposed to be filed, my lord.
Yes.
Lord,
Okay, heard Mr. Chikedas, learned counsel for the petition. Also heard MS and then Sharma, learned CDC for responder 1 and 2. And APJ,
Move copy to
learned counsel for the responders 3 to 7.
What is this?
Lordship,
Just placing the written
in this matter, we have already supplied the original record, Lordship.
Yes.
And in the original record, that original grade also there. Lordship, that may be recorded because we have to answer the authority, that original records.
The reports produced by the learned counsel for the responders 3 to 7 is placed along with the file.
Only
Is
one.
written by this court.
Lord, I have furnished my copy of the written submission to my friend, but no copy has been served to me, my lord, regarding the. written submission.
I was actually just got one. No, I'll give it, man.
Have you submitted your?
My copy I have given, my lord. I'll give it.
How about yours?
I have also given my written submission, but the
Interchanging has not happened. That is my learned senior.
my copy I has given to him, but.
We will
not
exchange it.
given me
We'll
this
give it
time.
to sir.
Give it to him.
We will put it in there.
Much obliged.
Item 1 of daily motion.
I please, your lordship. Lordship, in this case, the present petitioners were selected in Madrasa state qualified in the year 2015, my lord. And subsequently, their standard was pre-senior sections. And in general education, it is equivalent to upper primary and primary level, your lordship. Thereafter, advertisement was published to processing their applications, and accordingly the present petitioners as being the eligible candidate, they will in online mode they were submitted their applications, and after proper formalities they were submitted. Thereafter, subsequently, my lord, in the year 2019, their candidature were cancelled, my lord, by publishing a notification. In this case, my lord, the first notification was published in the page 2000.
Just a minute,
63.
who's appealing? Has the judgment been passed? Last occasion, you said that similar with petitions were heard. 18 to 2022 order. Have you seen the order? Last occasion, SMT Chisti met that submission.
My lord, he is not here today. Can it be taken after some time? I'll check.
After some time, you will.
My lord.
May I please, Your Lordship, the non-compliance of the order, it is page 31, Your Lordship, I guess.
Still now not complied.
Not compliant. He has
But-
been selected
Mr.
and Hoff.
And how learned counsel for the petitioner issue notice. Petitioner will take steps for service of notice on the sole
Sole
response
response.
by registered post within 1 week, list after 6 weeks.
3. My lord, order is placed at paragraph 17, page
Okay.
16. Directed the secretary to regularize my service from 1/11/19 within a period of 2 months.
1 minute. Two months. Third and sharper than the counsel of petitioner, issue notice.
Sole respondent.
Petitioner to take steps for service of notice on the sole respondent by registered post within 1 week, list up to 6 weeks.
My lord, 4 weeks, my lord, because I have already retired, my lord. Retired, my
It'll
lord, 4
come,
weeks.
it'll come 6 weeks. It'll go, then he'll have to engage a counsel.
My lord.
Or none appears for petition. List up to 1 week.
5.
May it please, Lordship. That's page number 10, Lordship, non-compliance of the order.
There no time limit was given.
Don't not time limit was given, Lordship, 3 months, but my, but other candidates have got appointment 1 year ago, but they have said that there is a proceeding pending. I have filed IA lordship, and then this court cleared that this is not bar lordship. So take a final call. Lordship till today, lordship, they are getting lordship, same selection, same. But they are still not giving appointment to me. Lordship.
We will dispose it of giving them a time limit.
Lordship.
But Mr. D. Mahanta, the council party petition. By this contempt petition. The petition is eligible. Non-compliance of the order pass of the order dated 19/4/2024 passed by this court in WBC number 1445 of the the operative portion of the order dated 19/4/2024 reads as under page 10 A to A. Stop. 10 and 11. Huh? Stop. A perusal of the order dated 10/4/2024 indicates that no time limit has been given by this court. Stop. Para. Accordingly, this contempt petition is disposed of, directing the Director of Higher Education, Assam, Assam, to comply with the directions passed by this court. To comply with the directions passed by this court by the order dated 19/4/2024 in WBC number 1445 of 2024 within a period of 1 month
Lordship.
with effect from the date of this a copy of the order of this court. Stop. With the above directions, the contempt petition is closed, is disposed of.
Obliged.
Say,
May I please your lordship? This is also of a non-compliance of an order. Operative part is at page 19, lordship.
Page
19, 19. Paragraph 19 and 20, lordship.
para 19 and 20.
Yes, lordship.
Page.
Page 19, lordship. Page also 19. Order starts at lordship page 10. So this order was appealed against, but appeal was also dismissed, lordship. The appeal is the order starts at page 20, next page. Appeal order, which was disposed of on 23/4/2024. lordship.
Okay, heard, Mr.
D. Dekha, lordship.
The declared constitution notice.
Sole respondent.
Petitioner will take steps for service of notice on the sole respondent by registered proceeding within 1 week. This of the 6.
Obliged, lordship.
7.
May I please, your lordship? My lordship is a clear instance of contempt of court, my lordship. Page 33 is the order, my lord. Your lordship has given 14 days outer limit time, my lordship, but still date. No, it has not been complied, my lordship. Para 6 is the operative portion, page 35.
Will you accept a copy?
Yes, my lordship. Page 36, my lordship. Receipt is on 17.
Okay, heard, Mr. P. Laskar. SP Laskar.
SP Laskar.
General Counsel for the petition. Issue notice. petitioner to take steps for service of notice on the who was directed.
My lordship, respond number one, my lordship, secretary to the government of Assam, my lordship.
To notice, petitioner to take steps for service of notice on the sole response by the state proceeding with the list of the 6 months.
My lordship,
Did it come up to 6?
Lordship, in this case, the Angus Council is on lake in foot number 10, my lord. Kindly may pass over for the timings.
My lord, here I need some more time, my lord. We have not received, my lord. One more last chance may be given, my lord, till Friday, my lord. If we will fail to produce any instruction, let the authority.
Your good name?
M.U. Ahmed.
But Mr. M. Ahmed, Learned Counsel, appearing on behalf of Mr. P. Provincial, Learned Counsel for the petitioner. Mr. P. K. Bora, Learned Standing Counsel,
Elementary education.
Elementary Education is allowed one week time to enable him to receive instructions. Stop list on 29th.
My lord.
Obliged.
Obliged.
9.
Well, today's fixed for instruction. Madam. Hey, 9.
Here I am praying for some more time, my lord.
Why?
We have, Inspector of School has been directed to submit a report in regard to the query that was raised by the supervisor.
At the time of provincialization, my lord, Gate 4 was not provincialized. Then this honorable court pass an order why they have not been provincialized.
Why the
Both.
order was not sanctioned at the time of provincialization.
Provincialization.
So therefore a report has been called by the director from the Inspector of Schools. Will require some more time.
How much time you require?
Plus 2 weeks time, my lord.
Let me please.
For MSK Devi, Learned Counsel for the
What I need you?
Mr. B. Kaushik, Learned Standing Counsel,
Give me the
Secretary
education.
Education Department, allowed another
Second time
time
needs to be allowed.
to enable him to receive instructions. It's on 7th August.
High levels, August.
10.
8 page, Lordship. Lordship, on the last occasion, Lordship, Inspector, my lord, to bring instructions, my lord. Accordingly, I have got the instructions, my lord, from the department.
Lordship.
The report of the DEO, my lord, is present there. It's in the second page, Lordship. Second page, the report of the DEO. Lordship will see the conduct of the petitioner, Lord. Conduct of the
Second page.
second page.
This one.
Yes, Lord. Second page is the report of the DEO, the District Elementary Education Officer, Borpeta. There, my lord, he has given the details, all the details. So may be allowed to read.
What? Yeah, 1 minute. Yes.
My lord. And Lordship, the meeting also was conducted. My lordship will kindly peruse the other documents.
Whether, my lord, earlier one meeting or two meeting, my lord.
Meeting was conducted, my lord. Photo also has been given, my lord.
Where?
Plus, my lord, in the last.
Where?
Whether any
Sixth page is the photo, my lord, and also, my lord, the 5th page is the form also, my lord, who all were present in the meeting. And my lord, The 7th page is all the people who have signed that because of his behavior is not good in my order. That is the, my lord,
Have you given them a copy?
my lord, I've not given, if I may be allowed to bring this on record, my lord, in form of an additional affidavit, because like this, my lord, giving also is,
Okay.
that will be better, I think.
It will be better. But Mr. Giudin, learned counsel for the petitioner, Mr. A. Fukan, standing counsel elementary education submits that he has received instructions and prays for how much time?
2 weeks, my lord.
2 weeks time to file
Affidavit, additional affidavit.
Declares allowed. List after 2 weeks.
Well, the date may be fixed, well, otherwise, because
List on 7th August.
11.
Lords, may please your lordship. Lord, hearing this case, my lord, other day matter was heard and copy was directed to be served to Madam Borua, my lord. We have served and she appeared, my lord. Hearing this case, my lord, the petitioner appeared in DL examination and admit card, his name, his parents' name, address is correctly recorded, but the photo is of different person. The principal, knowing him personally as he's attending classes in the center, he was allowed, and immediately after the exam, he submitted representation, my lord, dated 22/12/2018, Annexure 3, to the Director Evaluation of National Institute of Opening Schooling. My lord, may I pray for a limited prayer that the said authority may be directed to look into the matters, and if possible, maybe corrected, my lord. Names are correctly mentioned, his name, his parents' name. Only photo is of different person.
Diploma in elementary education.
Yes, my lord.
Yes,
That's it. Let me take instruction whether that DLED certificate was issued or not. Let me take instruction.
no, certificate was issued.
Certificate
Issued, but photograph
Photograph is of different
person.
name, father's name, all same.
But let me verify, Lordship.
Okay.
Only 4 or 5 days may be granted.
But Mr. A.R. Shikdar, learned counsel for the petitioner, MS R. Bora, learned standing counsel,
NIOS, National Institute of-
NIOS, prays for weeks time to enable her to receive instructions. Praise Allah. Please, after 1 week.
Develop.
For 6 to 9, I'm available.
Mr. A. Fukan, learned standing counsel,
Elementary education.
elementary education, affairs for respondent, 6 to 9.
12.
Lordship, the matter may be passed for the time being, Lordship.
Why?
Mr. MS Lobster is out of station actually, is on the way actually. So at 2 Lordship maybe.
Let him come after some.
Okay, Lordship. Master.
13.
May I please, your lordship. The petitioner before lordship is a block elementary education officer. He was placed under suspension because of some police case was there. But he was released on bail and his suspension is still continuing beyond 3 months. And no reason extension order has been passed in compliance of that Ajay Chaudhary man. Now at this stage, instruction may be sought for whether any reason order has been passed for extension of my suspension order.
My lord, the petitioner was suspended for being arrested.
Where's your suspension order?
My
Your lordship will find at page 32.
32.
The deemed suspension will pursuant to an arrest, my lord. Under rules, sub-rule 2, my lord. Rule 6, sub-rule 2. Your lordship will find the date of suspension 14/10/2023, page 33. Now lordship will kindly turn to page 37, my lord. So cause has been issued, statement of allegation has been served, he has submitted his reply, and the departmental proceeding is pending, my lord. So therefore, possibly, my lord, the question of reviewing would not come, my lord, because within 3 months, my lord, the departmental proceeding has been initiated.
Where's the show cause?
So far, your lordship will find at page 37,
December.
8 December.
That is within 3
He
months.
was suspended on 14/10. So cause under Rule 9, my lord. And with statement of allegation, he has submitted his reply.
1 minute.
Para 25 in my lord, our High Court's order, that is State of Assam versus Pranjal Bora, is 25, your lordship kindly see.
Okay, this is a case where suspension, so Rupert was served beyond 90 days. This level.
And in Ajay Kumar Chaudhary, page, my lord, paragraph 21. It is not.
No order has been passed.
No.
Reviewing your
No, no, that is the issue. The instruction may be sought for whether any order is passed, and I have no case.
Obtained an instruction, my lord, but before the 90 days period has
That is not,
No, that's a
that is
different
not
thing.
requirement.
Ajay Kumar,
Yes.
Ajay Kumar Chaudhary, my lord, where if the 90 days, if the so-called notice is not issued, then we are required to review the order of suspension and cite reasons for extension of.
and no, and even if you pass even if you give the charge sheet,
Then also.
you have to give a reason for it.
Then also.
It says, give the memorandum of charges. Para 21.
Directly currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charges is not served upon the delinquent officer. If the memorandum of charge is served, a reason order must be passed for the extension of the suspension. As in case in hand, the government is free to transfer the person so and so, so and so. The government may also prohibit him from contacting any person so and so. Para 24, my lord. So far as the facts of the present case are concerned, the appellant has now been served with the charge sheet, and therefore this direction may not be relevant to him any longer. However, the appellant is so advised, it may challenge his continued suspension in manner known to law, and this action of the respondent will subject to jurisdiction. Will take the instruction.
But Mr.
And
Stop. Para. While the petitioner was functioning as Block Elementary Education Officer, Jaguar, District Vishwanath, he was placed under suspension by a notification. Where is that
Page
notification?
32, my lords, notification dated 14/10/2023.
By notification dated 14/10/2023. Issue. No, he was placed under suspension, huh? Pending role of departmental procedure by notification dated 14/10/2023, issued by the Secretary to the Government of Assam, Department of School Education. Stop. Draft. Show cause notice dated 8 December 2023 was served on the petitioner. Stop. The grievance of the petitioner, the present recommendation is not, his suspension order has not been reviewed till date. Stop. But Mr. B. Kaushik, understanding counsel. Elementary.
My lord, elementary.
Elementary education department. Praise for some time to enable him to give instructions. Praise Allah. List after
2 weeks, my lord.
2 weeks.
After 2 weeks, any date, my lord, can be given.
List down. 9th August.
Right.
14.
May it please your lordship. Look, this is a matter pertaining to compassionate appointment. Further died on 13/3/2017. DLC recommended, the recommendation of the DLC, your lordship will find page 22.
Serial number?
Serial number 11. Applied within 1 year, applicant passed BA, applied for the post of assistant teacher. The DLC dated so and so discussed the proposal of the applicant and recommended in the eligible vacant post assistant teacher in LP school. Now it was forwarded to the SLC. SLC recommendation your lordship will find page 37. Serial number 11.
Seven.
Yes, madam.
Yes.
Serial number 11. Rejected due to non-availability of NCT norms and also do not come under the purview of OM dated 2/6/2017. Application date after 12/4/2017.
What is this?
Lord, 2/6/2017 I have annexed. This is an OM, your lordship will find page 57. This is with regard to the relaxation of minimum qualification for the post of assistant teacher in compassionate ground appointment. Last paragraph, lordship will kindly see, considering the above facts and pursuant upon the approval accorded by the government of India by notification dated so and so, the government of Assam has decided to further extend the period of relaxation for minimum qualification norms in respect of candidates applying for the post of assistant teacher of lower primary, upper primary school laid down in so and so retrospectively for a period with effect from 1/4/2015 to 12/4/2017 in respect of compassionate appointment. Now the SLC, so cutoff date is 12/4/2017. So what the SLC committed wrong is that, my lord, they have taken the date of application as the relevant criteria for determining the eligibility or relaxing the qualification as per the OM. Her father died on, my lord, 13/3/2017, which is much beyond the cutoff date of 12/4. So,
no, but when you applied, when did you apply?
Look, I applied on 13/6/2017.
Who is that?
Date of
Who is
application.
that OM again? Yes.
Yes, I'll just take your lordship to the OM. Page 57.
Has this cutoff date been extended?
No, I am not on that, my lord. 12/4/17 is the cutoff date.
Oh.
And applicants.
After 12/4/2017, there will be no relaxation.
That is true. That's true. But the father of the applicant, he died on 13/3/2017. So that date was prior to this 12/4/2017. So that date being a static criteria, that should have been taken into consideration while determining the relaxation for the petitioner.
How?
Milord, I'll just place. So far as other persons are concerned, there are, Milord, several other persons in the DLC minutes. If your lordships kindly see, merely because their father expired earlier and they have submitted application, lordship will kindly appreciate. 12/4/2017 is the cutoff date. If someone's father died on perhaps, Milord, 12 a year ago, so he'll submit application immediately within 1 month. So that application date will always be the before the cutoff date of 12/4/2017. Now this application date is variable. It is not static. It will depend upon lot variable factors. But date of date is static. Someone may apply within 1 month. Someone may apply because period is 1 year.
That's fine, that's fine.
So the SLC.
But then the office memorandum provides
Yes.
that the cutoff date is the relaxation is
12/4.
only
So
up to
my case is
12/4.
that my father being died before 12/4/2017. So I was entitled for relaxation.
How?
Milord,
How can you be entitled to relaxation on the date of your father? It will be the date when you make your application. When you make your, if you make your application prior to 12/4/2017,
My lord.
this OM will come into play. But after you make your application, after 12/4/2017, there will be no relaxation.
Lord, the latest Supreme Court, Honorable Apex Court has, Lord, laid down that the eligibility has to be on static factor. It has to be determinative. Lord, in this case, the applicant, because Lordship will kindly appreciate one thing. If someone's father died ago, he'll entitle for the benefit, and someone further died later, he'll not be entitled for the benefit. If someone applies within 1 month of his father's death and come within this, in between the 12/4/2017, then he'll be entitled. If someone applies lately, because this OM, your lordship will find, this was issued on 2nd June 2017. And I submitted on 12th, I submitted my application, sorry, 2nd June, I submitted my application on 13/6/2017. So it was not anybody's knowledge that this relaxation will be, the cutoff date will be fixed. So that's why, my case is that date of date will be the determining factor while considering the relaxation. Application, someone may give within 1 month, someone may give after 6 months. That's a variable factor. That will not be a determinative factor.
No.
If you are giving the relaxation, Milord,
No.
if you are giving the relaxation, it has to be based on a determinative factor.
And when was the SLC meeting held?
SLC meeting was held on, my lord, 22nd of January 2022.
Why are you approaching now?
Lord, we were never communicated with the decision of the SLC, Milord. We filed an RTI application.
Where's the application?
Yes. In pursuance to RTI application, this SLC minutes was furnished to us along with the OM on 18/5/24.
Where's the RTI application?
Milord, this is the communication by which, in pursuance to our RTI application dated 18/4/24, the SLC minutes and the OMs were furnished to us, Milord. Then only we came to know, Milord. At this stage,
This was available with you, isn't it?
no, Milord. SLC minutes was not.
SLC minus no. This reply was available to you.
Yes, it was.
Why couldn't you annex it in the writ petition?
Milord, while annexing the, I have, because it was enclosed with the SLC minutes, Milord.
Correct.
It just keep, Milord. It's my mistake. It should have been there in the
No, but the
annexure.
issue is this: you'll have to satisfy this court that this OM is applicable to you.
Milord, this OM is applicable to me by virtue of the date of my father, Milord.
That is not possible.
That is the, because
How can it be?
Milord, the reason is that the Honorable Apex Court has held that what rule will be applicable? Rule prevailing on the date of death will be applicable while considering the cases. Similar, if we apply that principle, Milord, this relaxation was up to 12.
Which
This
Supreme Court?
Milord, I have given a.
I have not come across such.
Milord, this is a recent judgment of Honorable Apex Court. This is 2021-20 SCC 797.
whether rules came in force on the date of the government servant would govern the field or those on the date of consideration of application applicable. Held is to be determined on determinate and fixed criteria such as date of death, not indeterminate and variable factor. The relevant portion your lordship will find para 18 onwards. Or lordship can take para 20, my lord. The important is
Yes.
the important aspect about the conflict of opinion is that it revolves around two dates, namely date of death of the employee and date of consideration of application of the dependent. Out of these 2 days, only one, namely date of death alone, is a fixed factor that does not change. The next date, namely the date of consideration of claim, is something that depends upon many variables such as the date of filing application, date of attaining of majority of the claimant, and the date on which the file is put up to the competent authority. There is no principle of statutory interpretation which permits a decision on the applicability of a rule to be based upon indeterminate or variable factor. Let us take, for instance, a hypothetical case where two government servants died in harness on 1/1/2020. Let us assume the dependents of these two deceased government servants make application for appointment on two different dates, say so-and-so and so-and-so, and a modified scheme come into force on 1/6/2020. If the date of consideration of the claim is taken to be the criteria for determining whether the modified scheme applies or not, it will lead to two different results. One in respect of the person who made the application before so-and-so, and another in respect of a person who applied after so-and-so. In other words, if two employees die on the same date and the dependents of those employees apply on two different dates, on one before the modified scheme come into force and another thereafter, they will come in for differential treatment if the date of application and the date of consideration of the same are taken to be deciding factor. The rule of interpretation which produce different results depending upon what the individuals do or do not do is inconceivable. This is why the managements of a few banks in cases tabulated above have introduced a rule in the modified scheme itself, which provides for all pending applications to be decided under the new and modified scheme. Therefore, we have considered view that the interpretation as to the applicability of a modified scheme should depend only upon a determinate and fixed criteria, such as the date of death, not on indeterminate and variable factor.
This is the thing.
So it has to be the date of death.
This is not applicable in your case.
This is in my humble submission, my lord. My lord, I'm sorry, my lord. Perhaps I failed to communicate. The issue is that here, my lord, the Honorable Apex Court has said date of application or date of consideration of the case is not a determinative factor. The determinative, because someone may apply within 2 months, someone may apply after 6 months. The determinative factor is the date of death. If my father's date of death is prior to the cutoff date of 12/4/2017, then I am entitled for relaxation under the OM. If my father would have died after 12/4/2017, I am not at all entitled, my lord.
Yes, if I can.
My lord. My
So
lord,
at this stage, my lord, lordship will examine the issue, my lord, at this stage.
My lord, that notification issued on 2017. That stated that the relaxation from 1/4/2015 to 15 to 12/4/2017. And other petitioner applied on 13/6/17 thereafter. Definitely, that's notification will not given the benefit to the petitioner. And it is the apparent from the Madan Lal and Rekha Chaturvedi case, my lord, that qualification that have to be on the date of application. That is very much apparent. And therefore, my submission is that, my lord, this is strictly legal, my lord. There is no illegality in this order, my lord. Otherwise, if in the case of the petitioner, there's something is different, the petitioner case is not taken into account as the assistant teacher, but as per his qualification, that I have no objection. But regarding this relaxation of qualification, my lord, that is very much apparent, my lord.
That is the thing. It's a loss.
Lord, my lord, I have got reservations with the contention of the respondents. Because in my humble submission, my lord, this is an issue to be decided, my lord.
My humble submission, going by the Supreme, there are other judgments also in the same line, my lord. Wherein, my lord, exactly an identical facts, this honorable court has taken a decision that an interpretation cannot be on the basis of indeterminate dates, my lord, or factors. If I am interpreting a statute, my basis for interpretation has to be static, my lord. Someone, say for example, in the present case, my lord, the father of the applicant died on 13/3/2017. This OM came on June 2017, 2/6/2017. So I was not aware. Nobody will be aware, my lord, that she'll apply prior to that. So she consciously applied, submitted application on 13/6/2017. So it becomes a variable thing, my lord. It cannot be, the interpretation cannot be on indeterminate criteria.
Okay, I'll issue notice for the time being,
Lordship,
but you'll have to satisfy this.
I'll satisfy, my lord.
Otherwise, I'm still not satisfied.
Definitely, my lord. I'll have to
Third,
satisfy.
educate us, learners council for petitioner. Issue notice. Who appears? Chief Secretary,
Chief Secretary, my lord, I declare.
Mr. P. Sankey.
My lord, 1, 3, and 4.
Government advocate.
My lord,
Appears for respondents,
1, 3, and 4.
1, 3, and 4. Elementary, MSK Das, the Understanding Council, Elementary Education.
5 and 6. 2, 5 and 6.
Appears for 2, 5, and 6. Notice on respondents are coming. However, extra copies, the furnished so and so. Respondents are allowed to have to list number 4 weeks.
Deeply on this.
15.
May I please. Earlier, this writ petition filed a writ petition before this honorable court. Lordship will find at page 23.
Page
23, Lordship. Operative portion, Lordship will find at page 26.
1 minute.
Order dated 15/6/2023.
Yes, then what happened?
Then Lordship, in terms of the direction passed by this honorable court, I submitted my representation at page 27 on 26/06/2023. But no action has been taken till date.
26.
26/06/2023. Till date, no action has been taken, Lordship.
Who appears?
I appear for BTC, madam.
Huh?
I appear for BTC. Direction was the respond number 2. Higher education, madam.
Yes, sir.
To the respondent number 2.
Yes, Lordship. Director higher education.
Director higher education. Yes.
Let's obtain instruction of that status of this.
Okay, we can direct the director to dispose of this representation.
Yes, that may be there.
Yes.
This.
Hmm?
Yes. In terms of provisions of law, as per law. Otherwise, there is no provision as per law for adjustment lordship. On the date of someone, there is no such provision. So.
Okay, heard Mr. Ard, heard learned counsel for the petition. Stop, para. Oh, no. Also heard Mr.
A.R. Tahir.
A.R. Tapildar, Learned Standing Council,
Higher education.
Higher Education, for the respondents,
Number 2.
for the respond number 2. 1 and 2, isn't it?
1 and 2.
1 and 2. Mr. S. Bora, Learned Standing Council,
BTC
BTC,
for 3 and 4.
for the respondents,
3 and 4.
3 and 4. Stop. For the petitioner had earlier approached his court by filing WBC number
2656
2656
of
of
22.
2022, which was disposed of by an order dated 15/6/2023. For the relevant portion of the order dated 15/6/2023 passed in WBC number 2656 of 2022, reads as under. Now, page 25, A to A. Stop here. Para. Draft, comma. The petitioner submitted his representation as directed by this court. No, submitted his representation in terms of the order. No. Drafted, the petitioner submitted his representation on 26/6/2023 before the Director Higher Education Assam. Stop. Before the Director Higher Education Assam, oblique respond number 2, as directed by this court on 15/6/2023. Grievance of the petitioner is that the representation dated 26/6/2023 is yet to be disposed of by the Director Higher Education Assam, oblique respond number 2, till date. But considering the short issue involved in this petition, considering the short issue involved from this petition is disposed of, directing the Director Higher Education Assam to consider the representation dated 26/6/2023 made by the petitioner in terms of the order dated 15/6/2023 passed in WBC number 2656 of 2022. And disposed of the same by of speaking on and in accordance with law within a period of 1 month from the date of receipt of a copy of the order with the above observations and directions.
Can it be 2 months?
Make it 1 month.
Obliged.
16.
May please, your lordship. And before your lordship, against the order at page 43. Order at page 43, lordship. Srimati Dahanti Gogoi Sheikha, accountant, SSA, Dibrugarh, is hereby released from contractual service on account of lapse of contract agreement on 30/11/2022. Lordship, now if I may take your lordship to page 32. 32, this is the order.
Page
32. 14/8/2015 order. Lordship got it. Said as otherwise expressly provided in service regulation and financial regulation of Assam Sarva Shiksha Abhiyan Mission is hereby notified that the spirit of rules and procedures as prescribed under the Assam Service Discipline and Appeal Rule 1964, followed by the Government of Assam for inquiry, departmental proceeding, award of punishment, appeal, etc., shall be followed by the ASSAM, and as and when an inquiry or departmental proceeding are required to be conducted in respect of any employee, contractual or otherwise, employees under so and so. So I am a contractual, but I have been released from the service without giving any inquiry or proceeding, lordship.
No,
On
but
the
what
straight
is
way.
this 30/11 on account of lapse of contract agreement?
Yes. But others are continuing.
Who is your contract agreement?
Lordship.
Where's your contract agreement?
Contract agreement, Lordship, yes.
Page 29.
Page?
Page 29.
29.
Contract was valid till November 2022.
Yes.
In paragraph, in handwritten, my lord.
November 2022. So your contract agreement has lapsed?
Yes, yes, Lordship, but page 32 is very clear that there should be, because there, I was charged with a charge that some misappropriation was done. Thereafter, I was arrested and put behind the bar, Lordship. Thereafter, I got bail, and because of this reason, Lordship, I have been released from service, Lordship. But others are continuing, Lordship.
Is there any contract agreement extending beyond November 2022?
No, earlier also it was extended from time to time, Lordship.
So from then, this is the last agreement, isn't it?
This is the last agreement, but
was it extended beyond November 2022?
no, because of my, since I was arrested and put behind the bar, so therefore this was not extended, Lordship.
So they did not bother to take a departmental proceeding against you.
But
they just said that since your contract agreement has lapsed, you have been terminated. You have been released.
Yes, Lordship, that is fine, Lordship. But since I was charged with a misappropriation, so as per that order of at page 32, there should be disciplinary proceeding because principle of natural justice is there, Lordship. Violation of principle of natural justice is there because.
No, there are two things in here, two things involved. One is that in terms of this order, if there's any disciplinary proceeding, that spirit of the Assam discipline appeal rules will be followed. Correct?
Yes.
They have decided not to proceed not to proceed against you.
The so-called notices were issued, and reply was also filed by me.
After that, they decided not to proceed against you. All they said is, since your contract agreement lapsed on November 2022, now you have been released since there's no extension.
No.
How can you do
on 15/5/2023 show cause notice was issued, Lordship?
No, show cause notice is another thing. This is another thing. But the issue is your contract agreement has lapsed.
Lapsed. This is fine, Lordship. Correct.
After that, what right do you have to continue?
Lordship, what I submit, let there be a notice be issued, Lordship, at this stage, and I'll satisfy your Lordship in this.
No. How can you issue a notice?
Lordship, because the show cause notice was issued, and I have replied, Lordship, to the show cause
Well,
notice.
If he had continued in service, then that application of Assam discipline may be applicable. But here is the service where his on November 22, his service has been lapsed. That period is over. Has not been continued. It's absolutely clear in the order dated 19 June 2023. It is challenging that the agreement has lapsed on 30/11/2022, and thereafter his service has not been. His service will not continue immediate effect.
If I may take your Lordship to
service, then it's a case would have been different. No, there is but now he is not in service.
If I may take your Lordship to page 37, this is the stopping of salary, Lordship. Page 37. With reference to the subject cited above, it is to inform you that as per the letter under reference, Srimati so Dibrugarh has been arrested on 4/5/2023 by the Dibrugarh PS number so, and accordingly she has been forwarded to judicial custody. You are therefore requested to stop the salary of Srimati Gauri. Because of this, Lordship, this termination release order was being issued, Lordship. But others are continuing. Similarly situated persons are continuing. I have stated in my paragraph, Lordship, the others are continuing. At page 23, paragraph 19, Lordship, I have stated. Page 23, paragraph 19, I have stated, Lordship.
Others are continuing?
Others are continuing, there are no complaints against them, but others.
No, that is a different thing now. Now you're changing your stance. You're changing your stand now.
No, others are continuing because there are 30.
Others are continuing without any extension?
No, there will be extension because there are 33,000 people are there. It extends, man. After every time, my lord, that we have to.
So
take
now
him.
what you are saying is others are continuing
Yes.
because there's no departmental proceeding against them. Automatically it shows that this order is wrong.
No, my lord. But Lordship will recall, I will now tell Lordship will recall another case, my lord. One Giyas Ali, Lordship has taken up that when AG appeared in this particular issue. Same incident. They have misappropriated more than 29 lakhs. This lady and the other person, and that case was filed. It was hard, my lord. Now, as on date, my lord, it is judgment is reserved from this is before Justice UK Nair, my lord. Judgment is reserved. It is pending, my lord. Same issue. We have filed a detailed affidavit on it. Why this department proceeding will not continue and how it has lapsed, and the person who is in contractual employee will not get that benefit because
Okay,
these are under civil post.
We'll consider this.
Not sir.
Heard Ms. R. Learner Council. Issue notice. Elementary. MS. You got her name?
That's for number 1 and
MS.
Kedas.
Kedas, Learner Standing Council, Elementary Education Department. Appraised for respondent 1,
And 4.
1 and 4. And Mr. S. Bora, Learner
Respondent
Standing
2 and
Council, SSA.
2 and 3.
Appraised for respondents 2, 3 and 4.
2, 3.
2, 3 and 5.
But in my case, there is no 5, my lord.
No
5 is there. 5 is not there, my lord.
I have 5 here. Page 7.
Oh, yes, yes, yes. The 4 is continuing with the 5. 4 will. In my case, there is no 5, my lord. 5 also. 5 is there.
2, 3 and 5, correct?
2, 3 and 5, my lord.
Notice on respondent may complete how rights to copies. Respondent are on the list of the forms.
Diploma. 18. Eighteen.
May I please, Your Lordship, as per order dated 23/9/22, issued by the Director of Elementary Education, Assam, the petitioner are entitled to
23/9.
23/9/22, Lordship.
Page.
Page number 32, Lordship. As per that order, petitioner are appointed, petitioner service was regularized as a tutor, Lordship, and their salary was, entitled to their salary with effect from 1/11/22. But the petitioners are paid only current salary from March 23. So, Lordship, 22, 1/11/22, 28 to 23, their area salary is not paid, Lordship.
Where has the director submitted the bills?
One list prepared by the Director of Elementary Education, Lordship, which is page number 23, Lordship. As per that list, Lordship, the petitioner service was regularized. There one issue was, one order was issued, and they are appointed as a tutor, Lordship.
Yes.
I'll issue notice now.
No, you take instructions. Heard MS?
A Begum, Lordship.
A Begum, Learner Council for the petition. By this week petition. The petitioners are claiming for error salaries with effect from 1/11/2020 to 28 to 2023. Stop. Mr. V. Kaushik, Learner Standing Council. Which department?
Elementary.
Elementary Education Department. Praise for 2 weeks time?
2 weeks.
2 weeks time to receive instruction. Please allow.
Date may be fixed, Lordship.
Please allow. 7th August.
Which one?
19.
May I please, your lordship? Lordship, this matter pertains to non-payment of leave encashment benefits of 300 days. Lordship may direct the present petitioners to submit their representation before the concerned authority. Respondent number 3.
Yes, thus we can dispose it of.
Your lordship, I may allow to, let this matter may verify your lordship once.
No, no,
I'll
let-
obtain instruction,
Let
your lordship.
make a representation and
Yes, your
director
lordship.
will make it.
As per law, your lordship. I mean,
Similar.
after verification of documents, your lordship.
Okay. Hurt MS,
NM Longking.
ML,
NM Longking.
Longking,
Longking.
Learned Counsel for the petition. Also heard MS. P. Das, Learned Standing Counsel, Secretary Education
Secondary
Department
3 and 4.
for the respondents. One also, I think,
Taking for some, yes, your lordship.
1, 3,
1,
4.
3 and 4.
And MS RM Barra, Learned Standing Counsel, Finance Department for the respond number 2. Stop. Barra. The petitioners before this court are retired principals of various high schools in the district of Dupri. Stop. Para. By this petition, the petitioners are praying for direction to the respondents to pay the earned leave encashment benefit to the petitioners for a maximum period of 30 days, 300 days,
300 days.
by calculating 30 days
30 days.
per year after deducting the leave engagement benefit already paid to the petitioners. But after hearing the learned counsel for the parties and on consideration of the materials available on record, this court is of the considered opinion that the interest of justice will be met if the petitioners file separate representations before the respondent number
Which it?
3.
3, Public Director of Secondary Education, Assam. But within a period of 1 month from today, stop. Thereafter, the respondent number 3, on receipt of this representations filed by the petitions and on verification of records and on verification of records shall consider the representations made by the petitioner and pass a reasoned order and in accordance with law to the respective representations of the petitioners within a period of 2 months from the date of the said representations. With the above observations and directions.
Deeply obliged.
20.
May it please your lordship. In this matter, senior counsel Mr. B. Datta is appearing. He is on leg in another court. Can it be taken after some time?
B. Datta.
B. Datta.
Okay.
I'll your life.
Item 1.
Kishti, last time you appeared in this matter.
Yes.
Has the writ petitions been disposed of?
Yes, my lord.
That document has been delivered, Lordship.
WBC 1 has delivered. And the connected.
These are similarly situated persons?
It verify that will have to verify, Lordship, after reading this judgment. Lordship, can I take it up on Wednesday, Lordship?
Okay.
It's a long judgment.
It is a long judgment, Lordship.
Third, Mr.
Which is the kindly date I may allow to see the date, my lord.
Your good name, please.
M. Ahmed.
Learned counsel for the petition. You are appearing, Kaushik?
Yes, ma'am.
On request made on behalf of Mr. On request made by Mr. B. Kaushik, Secretary Division.
Let it after a week, Lordship. We'll have to go and consult with the department also, Lordship. Let it after a week, Lordship. Any minute.
After 27 or 28, my lord, kindly. 27 and
Okay, we'll list after 1 week.
1, my lord, obvious. 17.
17.
May please, your lordship. The members of the petitioners association were dropped teachers, my lord, the elementary department. Now, after directions of this honorable court, there is a division bench order, which was again reiterated by a single bench of this honorable court. Their services were regularized from 1998, whereas as per the orders, it should have been 1991, my lord. So I'm seeking that direction, my lord. At this moment, I'm praying for a notice.
Okay, heard Mr.
P. Bharadwaj.
P. Bharadwaj, Learned counsel. Issue notice. Mr. B. Kaushik, Learned Study Council.
Secondary education.
Secondary Education Department.
1 and 4, my lord.
Is it secondary or elementary?
Elementary.
Elementary Education Department. Appears for respondent 1.
1 and 4, my lord.
1 and 4.
Lordship, I am praying for respondent number 2.
Mr. H. Alial, the Standing Council Finance Department appears for respondent number 2. Planning and Development.
GS.
And Mr. J. Beku, Learned Government Advocate, appears for the respondent number 3. Notice on respondents accompanied, however, extra copies of respondents are on the file affidavit. List of the forms.
Published.
21 to 51. Implement of party.
My lord, these IAs have been filed by the petition applicants.
Lordship, I kindly have a look at last order. This is order dated 19/6/2024.
(19/6) of the order.
And if Lordship, since this Lordship matter is getting listed before Lordship for a long time, Lordship will see the order passed on 23/8/2022 by your Lordships. That reflects the controversy that is there in this writ petition. 23/8/2022. That is the order passed by your Lordship itself. I can.
23/8/2022.
I can hand over this order. Lordships can have a look from here.
23/8/2022. In which, in the writ petition?
Will have a look. I have a copy.
Okay.
If I may just place this order, then Lordship will appreciate what is the controversy in this scope.
My lord, I can also place the facts.
No,
Now,
no,
what has happened-
Lordship, they are not even parties now. They just filed an application for implement, which is yet to be allowed.
Board, what is before the court is the IA filed by us.
No, the Lordship will
Your
also-
application is there, we also know. What is on board today is the IA filed by us. How can you stop me from making my
No,
submission?
Lordship will make, please have a look. We are the petitioners.
Nobody is disputing that you are the petitioners. In your petition, you have filed IA seeking implement. And that is on board today. Eight petition.
So Lordships, if Lordship read, after this matter went on, for some reason or the other, the government was not being able to give approval. Now finally the approval has come. So all that in terms of last time's order, this the BTC may give an instruction when the current salaries of us is being paid, because from 2015 it's a fact. Today, 10 years down the line, we are not being paid. So at least our current salaries be paid, because Lordship has itself noted, the course itself noted the hardship that we are facing for last 10 years. So even on the last occasion on 19th of June, when we pressed for this prayer, so the court ordered that on the next day, you will have to tell us the status of payment of the current, we are only now on the current salary. The arrear salary and all, that debate can remain for another day. But today there are 420 odd teachers who are not being paid. And some of them have died, some of them have committed suicide. So it's more of a human issue. There's no doubt that they are working, they are regularized since 2015, but are not being paid.
That is one aspect of the matter.
Yeah, today. So that Lordship will please kindly order that the current salary has to go.
No, what about this implement?
Yes, on implement.
Let me place my case on implement, then he can object. Did he not prevent me from making my submission?
No, I'm certainly not. I'm
Yes.
so sorry for the mistake.
My lord, what had happened in this case? The writ petitioners, they were irregularly appointed sometimes in 1999. They filed a writ petition for regularization of their services, which was dismissed by the learned single bench. Then they preferred an appeal. Now, in the appeal, an order was passed. Now, just now, my learned friend has made a submission that their services have been regularized, but they have not been paid their salaries. How far it is correct? Let us read the division bench order at page 47. Of your IA? No, of the writ petition. 6020 of 17. Okay. Page 47. 6/2/2015 order.
It's order dated 6/2/15. Please come to page 47.
Yes.
It is the contention of the appellants that appellants are also similarly placed and they should also receive similar treatment of law. The council appearing for the BTC submits that the policy decision is taken that persons receiving regular salary from the month of March 2006 would be regularized and implementation of the policy is in process. Government of Assam has also agreed to this aid policy. In view of the above submission, the writ appeals are disposed of with direction to the respondents to effect regularization as per policy decision of all those eligible teachers who were regularly receiving salary up to 17/10/2006. So, my lord, all that was recorded by the division bench of this honorable court was there was a submission made by the BTC that there is a policy decision. In terms of that policy, they would be regularized. Now let them show that order of regularization by which their services were regularized. This is not there. Now, my lord, what is our case? Now, we are all, my lord.
Who are you actually?
Yes, we are, my lord, 2023 batch of TAT pass qualified candidates who are aspiring to become, my lord, teachers, assistant teachers in LP and upper primary schools. We are 23 batch TAT pass candidates. Now, what had happened, my lord? There were two advertisements issued by this BTC authority. Advertisements are, my lord.
Chaudhary.
Yes.
Just 5 minutes.
Sure.
Have my medicine.
The BTC authority made a submission that there is a policy decision to regularize them. And in terms of the policy, they said that actions are in progress. So we have got nothing to do. Now, meanwhile, two advertisements were issued. Our only case is in those advertised posts, we have a right of application. Nothing beyond that. We may get the job, we may not get the job, that's a different thing. But those advertised posts cannot be usurped by these people. That is our only case. In that view of the matter, Lordships will take a call whether we are a necessary party in this process.
That advertisement already issued.
Yes. And now those advertised posts are sought to be adjusted by these people, by the petitioners. That is our case.
It's just stay. No stay.
By BTC. No, there is no stay. There is no stay. Now, what has happened? If your lordship would kindly come to the IA at page 135. Even the post paper.
Almost 1200.
Number of posts. And similar at page 135. With a view to support, strengthen and improve the quality of education in the state of Assam, in compliance of right to education and in presence of the BTC approval dated so and so, online applications are hereby invited to official website from eligible Indian candidates as defined in so and so, so and so, so and so, so and so, for filling up vacancies of assistant teachers and Hindi teacher of upper primary schools under the directorate of BTC. Now, this is the advertisement. And the other advertisement, this is in respect of upper primary, dated 7, and same advertisement at page 142. (142) is the advertisement in respect of lower primary schools. Now we understand, my lord, these are 1331 posts total. 1331. Now, out of this 1331, 931 persons identically placed like the petitioners have already been adjusted. Now there are only 312 Niki. 300 and odd posts are there. Now our case is this post should be made open to everybody. Let everybody apply. Whosoever gets it, gets it. Now, as far as my lord creation of post is concerned, as far as policy decision of the BTC is concerned, state of Assam is concerned, so far as regularizing them, that we have no grievance. But it cannot be at the cost of the post which have been advertised, in respect of which we have a right of application. That is our only case. So that's why we are opposing this petition. And regarding payment of salary, now let them pay, my lord. We are not against payment of salary to anybody. We are not against payment of salary to anybody. Our only limited right is we have a right of application. This post cannot be filled up by these persons. If government is so benevolent, let government create post, supernumerary posts, accommodate them. We have no objection. Because regularization is not a mode of recruitment. This same government of Assam often speaks of Uma Devi. Where have gone my Uma Devi got now? This Assam government, everywhere, whenever we file a petition, oh, Uma Devi, Uma Devi, Uma Devi. Now, where your Uma Devi has gone? Now, where is the regularization? Is not a mode of recruitment.
How many total posts? 1,300?
Yes. If your lordship will kindly take the affidavit filed by the BTC.
In the IA?
Yes, no, in the writ petition.
Oh.
Para 20, page 131. Para 20 at page 131.
Of the writ petition?
Yes, madam.
6020?
Yes.
Page 131.
Yes.
Yes.
That the answering deponent begs to
No, no.
state.
Something is wrong.
Page 131, Miller.
131 is.
Affidavit filed by the BTC. I think it starts at. Rani, please. It starts at 123, Miller.
Correct.
Yes, please come to 131. Para 20.
No. Isn't affidavit by respondent 3?
1 second. It is affidavit 6. 6.
Here's 3. 123 is respondent 3.
No, I'm referring to an affidavit filed by respondent number 6. That is the secretary, Boroland Territorial Council. Huh? I think, my lord, it starts at 155, my lord.
155, para 20.
155.
155. I think while giving the copy, my lord, something wrong in the presentation. We'll try to correct it.
Yes, respondent.
Yes.
This is 147.
Para 20, my lord.
Yes.
Yes. That the answering deponent begs to state that person to earlier sanctioning of 1009 posts by the government of Assam in various LP and ME schools, appointments were made and they were receiving their salary. That the government of Assam Finance SIU department on 28/12/23 sanctioned 1216 posts, that is 822 for LP and 394 ME. This is the two advertisement. That presently verification process is in progress to accommodate remaining dropout 304 number of teachers not receiving salary as the service have not been regularized against the valid sanction post. So contrary to the submission of my learned friend that they were regularized, the stand of the BTCs, their services were not regularized against any valid sanction post. Therefore, they are not receiving their salary. So on principle, my lord, we are not against their receiving salary. We are our only all that were. Now please come to para 22 at page 132. That the answering deponent begs to state that finance SIU department dated so and so sanctioning 1216 post, that is 822 for LP and 390 for ME, that presently verification process is in progress to accommodate the remaining dropout 313 number of teachers not receiving salary, as the services have not been regularized against any valid sanction. Thus, as per simple calculation, 1216 minus 314 902 posts will be available for selection as per advertisement dated issued by this so and so. Now that is what they would like to say, Milad. No. So this is the position, fine. So we say, as far as payment salary is concerned, let them pay. We are not objecting. Only case is whether this post, the advertised post, should be made open to all, because government has not taken a decision to recall the advertisement or anything. The advertisement is on. Now the question is whether the authority can adjust these persons against this post. Let government do take whatever decision they want to take regarding the regularization. That is not our case. So this is our limited perspective. So in that view of the matter, since we are aspiring to be teachers, assistant teachers in LP, ME school, I think we are a necessary party to these proceedings and our rights should be adjudicated. That is our case, matter. And therefore we should be implemented. And today the matter has come for implementation, not for any other purpose.
My lord, I have strongly objected, my lord, because your lordship kindly see their cause of action is totally different and our cause of action is totally different, my lord. My lord, your lordship kindly see, my lord, our post has already regularized. Your lordship kindly see there is a writ appeal. What happened, my lord, if your lordship go to the history of this case, my lord, in the 1999, my lord, your lordship kindly say long back, my lord, there was a recruitment process in all over Assam. So considering the proper procedure, my lord, all over Assam, the teachers were appointed, my lord, including, my lord, undivided, my lord, that is, my lord, Nalbari district. But when creation, your lordship kindly see, so far is Nalbari district is concerned, my lord, 2,272 posts were, my lord, created. So 2,270 posts, my lord, persons were appointed. But in 2002, my lord, so BTC was created, my lord. When BTC was created, my lord, out of these 2,272, my lord, 906 are in Nalbari districts, other in BTC, my lord. So now when BTC come to in force, my lord, they were terminated. But same selection, my lord, who are in Nalbari, they are getting salary, they are retired, they are everything they are getting. No problem. Because of the creation of the BTC, my lord, whole trouble was created, my lord. Now, my lord, these were terminated, then they came before this honorable court. And this honorable court was, my lord, the petition was dismissed. Then filed a writ appeal. The writ appeal was, my lord, during that process, my lord, BTC authority take a resolution. On the basis of that resolution, my lord, they keep this post and their services were regularized with effect from 2015. That order I'll place, my lord. Before that, my lord, my lord, writ appeal order, although, my lord, because of the decision taken by the BTC authority, my lord, writ appeal order was passed. But that writ appeal order was, my lord, reviewed by there's an application filed by review application was filed. But that review also dismissed, my lord. In that review application, my learned friend is appearing on behalf of the petitioner like us. The same who are petitioner here, my lord. I'll read that order. I'll come to that, my lord. Now, my lord, on the basis of that, my lord, decision taken in by the revision bench, my lord, our services were regularized. My learned friend says that there is no regulation. I'll place the regulation order in my case, my lord. Your lordship kindly see. Page 58, my lord, that first case, my lord, page item number 21. Page 58, your lordship kindly see.
Item 21 is
That my lord, WPC 6020,
Page.
page 58, my lord. Similar order in respect of all petitioner, my lord. Page 58, has your lordship got it, man? Page 58. In pursuance to the Honorable Guwahati High Court, judgment and order dated 6/2/2015, passed in writ appeal number 182 of 2013, based in the evidence of miscase number so-and-so filed by the BTC, consequent upon BTC exercise council meeting, headed resolution number so-and-so, departmental meeting and education department, resolution number 4 dated so-and-so, respectively in consonance of the approval or receipt from BTC by the order dated so-and-so, and on being terminated order withdrawn by the BTC by the order dated so-and-so, and Ganesh Nazari, who was terminated from service, order dated so-and-so, issued from this end, is hereby withdrawn and his service is regularized. Reinstated as the assistant teacher in the Banarbadi Bandarbat LP school, scale of pay of so-and-so, plus other so-and-so. Thus, regulation of the service of the individual teacher shall be subject to the following terms and conditions. The regularization order shall be came into force with a prospective effect. The supplementary demand proposal for the individual teacher has to be made by the Director of Education, the BDC onward submission of the so-and-so, and so. The drawal of regular salary of the individual teacher till 7/10/2006 has to be authenticated by BDO, concerned by duly so-and-so. The teacher's pension provision will govern by as per government rule in force. So that is our regularization order. Our order was passed that their service will be regularized with effect from 2015. Although it is 2015, our service has been regularized, but no salary has been paid. Then we approached this honorable court, my lord, this petition was pending since 2017. Then there is a lots of order passed by this honorable court to pay the current salary, no current salary has been paid, my lord. Some of still, my lord, some of the candidates, they are not getting, my lord. Now, my lord, what pay are made in this petition by us? We said that yes, our salary should be paid, and instead of prospective regularization, we should be retrospective pilot regularization. That is our parent petition. So our cause of action and their cause of action is totally different, my lord. Now some post has been advertisement, my lord, that will take their own course, my lord. We are not going to take their post, my lord. But our service has already been regularized.
No, but then the affidavit filed by the respondent number 6.
My lord, that will respond, my lord, probably a few days back, my lord. I will answer that affidavit, my lord, because I have not. But that is the reason, my lord, I am submitting.
I'll clarify one thing, my lord. If the authority says that advertised post will not be used for adjusting them, we are out. We don't have any grievance.
But our case is that we are not paying for regulation, my lord. Already we are regulation from 2015. That position is intact, my lord. That in fact, my lord, your lordship passed an order, everything clearly, my lord, written in earlier order by your lordship, my lord. Because our from 2015, my lord, we don't need any regulation. Our salary should be paid, but we paid our regularization retrospectively because we are working since 2019, my lord. Up to 2008, we get the salary, my lord. From 2008 to 2015, we are not getting salary, nothing has been paid, my lord. So now, my lord, again, my lord, as per the direction of the appeal order, my lord, they regularize it from 2015, my lord. So that is our case, my lord. That's why my lord, objecting their implicit petition, my lord. Their cause of action is totally different, and our cause of action is totally different, my lord. That is my submission. And so far is, my lord, again, I am pointing out, my lord. I probably says his clarification, my lord. Earlier, my lord, in review a petition, he is, my lord, appearing on behalf of this petitioner, my lord. But clearly mentioned, my lord. In fact, he has annexed the order also, my lord.
No, that's fine. That's fine. If you are saying that this is for salary and retrospective
regularization, my lord.
Without
that is our case, my lord.
Without entry, without trying to take away the post advertise, that is fine. Then maybe they have no case.
My lord. No, that is our pair, my lord. I cannot go out from my pair, my lord.
No, fine. But then the respondent number 6 has created the trouble.
My lord, that I have to, my lord, answer, my lord, because I have not answered that. I have not even received, my lord. That is, my lord, what they have stated, my lord.
We have intervened.
Because, my lord, now, my lord, it seems, my lord, they are in hand in gloves, my lord. Your lordship kindly see government, my lord, last 7 years, they have not been filing affidavit. Now, my lord, when implicit petition come, my lord, they file affidavit, my lord.
Who is the respondent number 6?
I answer that, my lord. I will write application.
That I'll permit you.
Secondary BTC.
What affidavit could be?
Who appears BTC?
affidavit খন দে কেতিয়া দিছে
What is this para 20?
আমি ৰিপ্লাই দিম সেইটো চাব লাগিব তুমি আমাৰ লগত নহয় নহয় এইটো
Well,
Contract.
it has a long history, man. Initially, the termination, it was terminated, they were terminated.
No, I recollect,
They-
I recollect
all-
those
all-
history now.
All this has gone. Writ petition, they are terminated, upheld, appeal filed, policy decision was taken. Now, in the policy decision, it was said that the BTC has taken a policy to regularize it. Then came the review petition from the finance department, that the finance department was not consulted. In the meantime, my lord, during the pendency of the review petition, 1009 posts were sanctioned to BTC to accommodate certain persons who are here. These persons were accommodated. In the meantime, the persons, more than 1300 petitioners are there in this batch of petitioners, out of which, as on date, only 314 are not getting salary. Rest all had been adjusted, they are getting salary. So the process of this, now in the meantime, my lord, on 28/12/2023, finance gave a sanction for 1226 posts, 1216 posts. Now, as the affidavit says, my lord, these people, 314 persons who are still not getting, but they will be accommodated. In the meantime, advertisement were issued. In the IA for implementing, there are 241 persons who has come before the court saying that they should be accommodated. And if lordship gets it, there are more than 902 posts to be advertised in the.
You've already advertised.
Already advertised, man. There will be 902 posts.
So what is your affidavit para 22 saying?
Para 22, my lord.
Last 4 lines.
Yes, my lord. There 200, as on date, my lord, there are sanctioned posts of 216. 216, 314 numbers of posts, among the institutions we have to accommodate. That will accommodate, minus that, it will be 902 posts for both the petition. Post will be available.
See, what you could have done was you could have accommodated these petitioners, thereafter made the advertisement. That would have been much more simple. Now you've created, you have made the advertisement, now you file your affidavit saying from that advertised post, we are going to accommodate.
Not from the advertisement,
314.
because there is in the advertisement, there are not, posts have not been declared, my lord. No post you given in the post.
No,
This is the
but
post.
you're
No,
saying
what's the
1000
advertisement will say there is no post, fixed post.
If lordship will kindly have a look at the advertisement, because the advertisement has not been placed correctly.
No, no, let me place.
No, no, let me place it. Yeah. It has not been, the relevant portion has not been pointed out in the advertisement.
I'll place on. Please come to the IA, my lord. Please come to the IA at page 135. Before that, lordships will kindly come to the SIU approval at page 133. Clarification for filling up 1 to 8 cent number of vacant post of assistant teacher under BTC area, that is LPNME. With reference to the subject cited above and letters under reference, I am to inform you that as per minutes of meeting held with the Honorable Minister Education Assam on so and so, the director had written a letter to the Special Commissioner with request to expedite the proposal for SIU approval for filling up 1287 number of vacant post of LPME teachers under BTC. Boroland Territorial Council has submitted a proposal to you seeking approval of finance SIU for filling up 1287 number of vacancies lying vacant in various LPME schools, white later dated so and so. Subsequently, clarification was sought from your end. Accordingly, matter has been clarified white later dated so and so, wherein it was stated that earlier proposal for SIU of 1287 number of vacant posts should be treated as 1216 number of vacant posts of assistant teachers of LPME school. It is further clarified that original proposal submitted by Director Education, BTC for 1287 number of posts has been corrected by him and number of posts now stands at 1216 number. It is further clarified that proposal for 1287 of assistant teacher lying in various LP schools as submitted by earlier director and proposal submitted from this end for SIU of 1216. Therefore, initially it was 1287. Subsequently, the SIU approval was for 1216. Now, my lord will kindly, lordships will kindly take note of this number to put us later. Number 2. Yes. Now, my lord will kindly come to 135. The number of vacancies have been approved by Finance SIU department and communicated by Department of School Education via approval letter number E259464 dated 29/12/23. So everywhere lordships will find this number. Approval number E259464/1465 dated 29/2/23. Yes, the number of posts is not indicated, but SIU approval was for 1216 posts. And during the course of hearing before this honorable court, this aspect of the matter was clarified. I'll order it. Huh? 1 second. Yes. Please come to Milord order dated 18/12/23.
In this IA?
Yes. No, in this writ petition. No, my lord. WPC 5281 of 2016. It is here now. 5281 of 2016. Order আছে না? order আছে না? order আসলে জোট পেছিল সেকেন্ড টাইম যেগুলো ডিটেইলস
Order date?
Yes. Order dated 18/12/23.
Yes.
The first para, B. Gogoi Lanet Standing Council Finance has placed the communication dated 14/12/23 and submitted that the proposal contained in e-file, that same number, is under active consideration of the department as the matter requires proper evaluation for sanctioning of the proposal for filling up 1216 number of assistant teacher under BTC area. It is further submitted that 421 teachers who have claimed to have not received salary are also included within this 1216. These are the orders for which we had to come before your lordships. Then Milord will kindly come to order dated 14/5/24.
Same writ petition?
No, I think 2060. 6020. No? 6020.
14?
5/23. 24. And your lordships got it. I think the order would be in the IA also. 14/5/24. It IA to the order. Hmm? (14/5/24). Honorable Justice Sumitra Soike has ordered.
Yes.
Yes. Please come to para 4. What is our case? Sri Ken Chaudhary Lanet so assisted by submits that this interlocutory application has been filed for implement of the applicant as necessary party in the present proceeding, namely so, as the applicants have filed their necessary applications pursuant to advertisement dated 17/1/24 for filling up vacancies and assistant teacher in lower LP and upper primary school. The grievance of the applicants are that vacancies have been approved by Finance SIU department, communicated to the Department of the School Education by the approval letter dated so. The applicants have all applied through online applications and claim to be duly qualified at that pass, and they are waiting for proper selection and appointment to this post, which were advertised by. None Senior Counsel for the applicant submits that pursuant to the advertisement, when the posts are required to be filled up by a direct recruitment, then these posts ought not to be filled up by a regularization by government, as is sought to be done by accommodating the writ petitioners. Accordingly, as permitted, respondents will place the current position in respect of the vacancies available sought to be filled up by an advertisement dated 17/1/24, as well as vacancies available for regularization of writ petitioners by filing an affidavit. Pursuant to this order, my lord, that affidavit has been filed, wherein paragraph 20 and 22, the position has been explained. And there is no dispute that by this, my lord, file 259464, dated 29/12/23, 1216 posts were approved by SIU, Finance SIU. So though number of posts is not mentioned in the advertisement, but there is no dispute because BTC has come up with their own clear stand. So therefore, as far as the number of posts is concerned, I don't think there is any, confusion. It's very clear. So it pursuant to this order, this affidavit was done, where they have come out with a clear stand. Now they say, if they are to be accommodated, then that 1216 will come down to 902. So therefore our case is, my lord, we are a party, necessary party to this proceeding, or before passing any order, we should be heard. And my lord, for a moment, we are not against payment of salary to anybody. Let government, the authority make payment of the salaries. To that, we have no objection. Our only right which we are claiming is right of participation in the selection process. More so, when the Supreme Court has repeatedly said, my lord, regularization is not a mode of recruitment. If you want to get service, please, by all means. And if in any post other than this, they can be accommodated, that we are not objecting. That is our case. So we need to be hard in this matter.
Yes, Gogoi, last time you said that out of this 1216 posts, the post of the petition is also included.
Yes.
No, that's not there in the proposal. But in the finance part is concerned, they have submitted a proposal identifying certain posts. That's how you approval is given for those posts. Now, any say out of 1200, something say 200 is advertised or 200 posts is filled up. Same SIU number will have to be mentioned there.
Yes.
It's not that 1200 we have given, so 1200 will have to be advertised. It's up to the authority. Whenever they give any appointment to those posts, SIU approved posts, that number will have to be mentioned. Without that, the salary will not be released by the treasury. That is the rule of the finance department. Now, out of this,
So irrespective of the sanction of 1216 posts.
they can fill up 500 also, they can fill up 1200 also. As per their need, they will do this. But we have given, because there is a particular validity of this particular approval. It will be for a certain period. If they do not fulfill it within a particular period, then sanction will go. The approval of SIU approval will go. They cannot keep it in the group. It is always mentioned. That's why in a single appointment also it is mentioned. So in so SIU approval.
It will be a common number.
Yes, common number for all those posts. Single appointment will be issued subsequently.
And then again, Bora, it comes back to you again.
So it's there.
There is one caveat to what my learned friend Gogo has said. He said that we have sanctioned 1200 posts and it is up to whatever it is. And it is up to the BTC authority to fill up those posts in any manner. That cannot be a correct submission, my lord. That manner has to be consistent with Article 14 and 16.
Of course, my lord.
Yes. Yes.
Illegally something.
Yes.
May I just 1 minute? Yes. I'm just trying to clarify. No, I think you are the culprit.
Now we are trying to.
See, the issue is the one side, there are these petitioners who are waiting for, they said they've got the regularization order. They have to be accommodated to some post. So 1216 posts, that was sanctioned by the finance. Recently sanctioned.
Earlier, when a total petitioners is more than 1300. 1300, most of them have received it. From the salary received it. Only now it is remains is 314.
No, 314 is there.
14.
So how many posts have you advertised in the advertisement?
None. But that number has not been given, madam. From the sanction order has been given by the.
Sanction order is given, that is fine.
16. Out of which, my lord, I have given the in that particular affidavit once. Now it will be open for 902 posts. 902.
And
So are you saying that you have advertised 902 posts?
now it will be open for 902 posts. Now. Rest will be consumed by.
No, how many posts have you advertised by way of your two advertisements?
Though the advertisement is not clear, my lord, but
No,
will
it
be
is clear.
902.
This is the problem.
It is clear.
You're just creating all this problem.
It will be 902.
If you say that we have deducted 314 posts and this must have been advertised. Chowdhury's client would keep quiet.
One of my senior counsel, there's no, because their total number of petitioners is on 214. Post available is 920, 902.
And so many other people will also apply.
They will also apply, but there is, they will also,
No,
they will also.
the issue is you should be specific. How many posts you have advertised in the admit? How many posts you have advertised?
Then I need to take a.
Then after that we'll have.
That the category on oath, it is there.
That we have seen. That we have seen. Your para 20 and para 22. Para 20 and para 22. That this court has seen.
I have given 900 support to be available for both para and para.
Just fine. But then the advertisement which you made on 27th of January, that one does not indicate the number of posts. How many posts have you advertised then?
Only indicated to me that the.
No, that is what this dilemma is coming out. And the petitioners are also not very sure how many posts have been. The applicants are also not very sure. And you have not made any.
In fact,
Advertisement is vague insofar as the posts are concerned.
number of posts they have not. Because they have to accommodate those petitioners.
That's fine, that's fine. This court is not saying you cannot accommodate the petition. You have to do it. There's already an order. You have to do it. Minus this post, you could have advertised. That would have made things simple. Avoid all these litigations, unnecessary litigations.
If Lordship will kindly come to page 135, the advertisement itself is very clear. The advertisement, page 135, annexure A2. It is true that the advertisement doesn't indicate the posts, but what Lordship will have to see is the conditions of recruitment towards the bottom of the page. And please come to condition number 17 at page 136, which is being missed out. The advertisement is very clear. The vacancies may vary due to administrative reasons and matters under sub judice before the Honorable High Court. So it is very clear, the PTC was very clear that within this, the matters which are sub judice, these are the 314 people that we are, will have to be accommodated. And therefore, this condition will have to be read. Therefore, the numbers have not been indicated, Lordships. This is very critical. 314 posts. And please, Lordship, one thing Lordship will kindly bear in mind. What is now being sought to be implemented by BTC? BTC is trying to implement the division bench order. And today we are not sitting in appeal over the division bench order.
No, that's fine.
So therefore, and out of all those people, everyone has got the benefit except for this poor 314 people.
Bora, come here.
So therefore, please, Lordships.
Direct us to release the current survey. What is this condition 17?
If it cannot be Yes, 135, page 135. Vacancy is given. Vacancy is, we have got 12, now we have got 12 and 16 posts. So there, and the rest other cases are pending. Initially it was 1300 on odd. We have given him accommodated. Now it has come down to our calculation. We have already made a verification. Our calculation, it has come down to 314. We have to accommodate. Now, that's the reason that condition was given. Madam. The present situation is that verification done, tabulation is going on. Very final stage, it is in the final stage. Most likely within 10 days, the tabulation will close. Thereafter, all these 314 people will be against the sanction. Now they are working in. That's all we want. But it will take another
10-15 days to final the tabulation. As on the tabulation, people are sitting, group of people are sitting and making tabulation, everything. For this 314 persons. After the
And lordships, in any case, the applicants are just 241 and there are 902 posts available for them. So what could be their grievance? There are only 241 applicants in the IA.
No, the issue is that you've made the advertisement in a haste manner, that's what.
But then lordship,
Undue haste.
because the condition is also there when there, what will be outcome of the repetition that till you have to face for it.
Outcome of the repetition would be now that you've got the sanctions imposed, it will be only whether they will be given retrospective regularization or not. Once you accommodate them in this 314 posts, the only issue will now be whether they will get the retrospective regularization
and the area.
and the area salary. That's all.
That is our case, lordships.
That's all.
Now it is.
But with this advertisement, now the third party is coming, saying that no.
Third party comes here because posts are available.
Lordship will kindly appreciate. Third party is asserting a right which may or may not arise. As on today, they don't have a right. They are not people who have been selected. They are trying to write and assert a right in future. Now the question is whether a person who is asserting a right in future, which may or not may accrue to them, can be an impleader in this present proceedings is the case, is the position of. And the Supreme Court has been very clear on this. If I may just place the judgment, that you cannot assert a right. You have to have a current and present right to get implead with.
And also, my lord, they have come only on one expedition. Each and every expedition they should have filed.
Please see this judgment, lordships. This is in the context of specific performance by the principal. And this is a very illustrative judgment. Lordship will kindly come straight to para 8. This is Mumbai International Airport Private Limited. 421. Kindly come to para 8. Or lordship, please come to para 10. I am just reading what the learned single judge did and what they. A learned single judge dismissed the appellant's application by an order dated 1/4/2008. The learned single judge was of view that as the appellant was yet to acquire any interest in the suit land, and as the pending suit by the first respondent was for specific performance of an agreement which was a distinct earlier transaction between the first respondent and AAI, to which the appellant was not a party, and as the first respondent was not a party to the arrangement between AAI and the appellant, the court cannot permit impleadment of an appellant with reference to some future right, which may accrue in future after the decision of the suit. The appeal filed by the appellant was also dismissed by the division bench by an order dated 25/8/2008. The division bench held that the appellant did not make out a case that he was a necessary party, and the application merely disclosed that he was only claiming to be a proper party, that the appellant's claim was not based on a present demise, but a future expectation based on space successionists, and that therefore the impleadment of the appellant was neither as a necessary party or a proper party or a formal party was not warranted. The said order is challenged before his appeal. Now, see, lordship, please kindly come to para 13. The general rule in regard to impleadment of parties is that the plaintiff in a suit, being the dominus litis, may choose the person against whom he wishes to litigate and cannot be compelled to sue a person against whom he does not seek any relief. Consequently, a person who is not a party has no right to be impleaded against the wishes of the plaintiff. But this general rule is subject to the provisions of Order 1, Rule 10(2) of the Code of Civil Procedure, for which provides for impleadment of proper and necessary parties. The said rule is extracted below. That is when the court wants it. I'm not reading that part. Now, please come to para 14. The said provision makes it clear that a court may, at any stage of the proceeding, including suits for specific performance, either upon or even without any application, and on such terms as may appear to be just, direct that any of the following persons may be added as a party. A, any person who ought to have been joined as plaintiff or defendant, but not added. B, any person whose presence before the court may be necessary in order to enable the court to effectively and completely adjudicate upon the settle the questions involved in the suit. In short, the court is given the discretion to add as a party any person who is found to be necessary party or a proper party. Para 15. A necessary party is a party who ought to have been joined as a party and in whose absence no effective decree could be passed at all by the court. I'm just stopping here for a moment. Is this case that if they are not implemented, that lordships cannot pass an effective order on a relief? That is the first question. A proper party, if a necessary party is not implemented, the suit itself is liable to be dismissed. A proper party is a party who, though not a necessary party, is a party whose presence would enable the court to completely, effectively, and adequately adjudicate upon all matters in dispute in the suit, though he need not be a person in favor or against whom a decree is made. If a person is not found to be a proper or necessary party, the court has no jurisdiction to implead him against the wishes of the plaintiff. The fact that a person is likely to secure a right interest in the suit property after the suit is decided against the plaintiff will not make such a person a necessary party or a proper party to the suit for specific performance.
Yes.
Now, just last paragraph, lordships. Para 18, lordships. One last paragraph I'll just place and then I'm done, lordships. Sorry, lordships, para 22, 23. Para 22, 23, lordships.
Page 420.
Now their lordship is come. Let us consider the scope and ambit of Order 1, Rule 10, 2 CPC regarding striking out or adding parties. The said sub-rule is not about the right of a non-party to be impleaded as a party, but about the judicial discretion of the court to strike out or add parties at any stage of a proceeding. The discretion under the sub-rule can be exercised either suo motu or on the application of the plaintiff or the defendant or on an application of a person who is not a party to the suit. The court can strike out any party who is improperly joined. The court can add anyone as a plaintiff or a defendant if it finds that he is a necessary party or a proper party. Such deletion or addition can be done without any condition or subject to such terms as the court may deem fit to impose. In exercising its judicial discretion under Order 1, Rule 10(2) of the court will, of course, act according to reason, fair play, and not according to whims and caprice. And 24.2 and 24.4, lordships. (24.4) at page 426. If an application is made by a plaintiff for impleading someone as a proper party subject to limitation, bona fides, etc., the court will normally implead him if he is found to be a proper party. On the other hand, if a non-party makes an application seeking impleadment as a proper party and the court finds him to be a proper party, the court may direct his addition as a defendant. But if the court finds that his addition will alter the nature of the suit or introduce a new cause of action, it may dismiss the application even if he is found to be a proper party. I leave it at that. If adding him will change the nature of the writ petition and bring in a new cause of action, the court still has the discretion to dismiss the impediment application. You cannot introduce a new cause of action by getting yourself impleaded. And today, as the affidavit says, there are 241 applicants. There are 902 posts available for them. Spare a thought for us, lordships. These are people who have just applied. They have not even been selected. They are trying to exert a right in future. They may pass, they may not pass. And the IA is also very clear that they just want to apply. Now, if they are saying the right to apply is a fundamental right or not, so lordship will kindly have a look that we are people who are waiting in the wings since 2015. Let someone not come at the last moment to jeopardize us when we are at the final stage. At least this 341, that is my humble request, lordships. We have been, as lordship yourself noted, that we have not been paid salaries. Now, if this new thing comes in, we will again be back to square one and fighting a new battle, fighting a new cause of action, which the Supreme Court has also said that the court should not permit. I bow down, Lorships.
May I please? এটা short form এটা দেখাম মোৰ I am 52 identity. চব পইচা দি দিছে কেৱল লিখিত পাইছে
In fact, Lordship will appreciate that the BTC and us,
মোৰতো 15 লৈকে পইচা
the
দিছে
authority and us are on the same page that they should not be implemented. They are not, if I am not mistaken, Mr. Bora.
I'm not opposing, I'm opposing the implementation.
Exactly. They are opposing like us, they are opposing the implementation.
well I point out only short point ballot in my case ballot in 52 item number 52 page 19 in my page I am this file is available ballot I have given salary up to 15 first 15 October 15 from I was appointed in 1919 to 2009 I am getting salary thereafter up to 15 I am getting salary my lord and from plan to non-plan I am adjusted my lord thereafter what is the necessity to regularize me in any other post my lord that kindly your lordship go to the one order my lord at page 19 I am reading my lord in compliance of the Honorable High Court's order passed in WPC number so and so in pursuance of BTC executive meeting dated that the Bodoland Council is pleased to sanction and release an amount of exceeding 14,90,000 and so and so and so only being the payment of arrear salary in respect of the petitioner Biju Demari assistant teacher Goramdev LP School under Baska Education Block Baska District with effect from 1/9/2009 to 13/6/2015. That my lord, the expenditure will be made the council fund under the head of the account so and so deposited personnel deposit BTC and debitable to the head of the account so and so and said government primary school 166 Gov primary school during the financial year 2016-17 non-plan. Earlier my appointment was in plan. Thereafter in non-plan I have been given all salary up to 15. So my lord, question of regularize me subsequently does not arise. I have to pay only the arrear from 15 itself. So my lord, so it is my idea, right?
And our regularization orders have all been passed in pursuance to division bench order. Our regularization is done in compliance with the division bench order.
So
on which we are not sitting in appeal today.
Whatever that, my lord, my case has already been regularized. Why I am not paid, my lord? It's a 52 appeals available. And that the earlier order, your lordship, has been passed in this case, my lord, 7/2/81. In this case, my lord, the earlier order for paying salary was given. Order to this. In my case, that was the order was passed, my lord.
How many IAs are here?
Only one I.
Only one.
Of 241 applicants. And there are 902 posts for them.
IA is only one. Only one.
And Lordship will also appreciate that the IA has been filed only in one matter.
Yes.
So in that, but
In that
earlier
case
case
also it
has
is
been
not
not
maintainable.
connected.
They've only filed it in one matter.
Okay. And this is what?
I am appearing in item 31.
Acha, IA has been filed in TJ Mahanda's case.
Yes.
Correct.
The first 6020/2017.
6020.
Yes, sir.
So we are considering this IA only today.
Yes.
And also will Lordship will consider the current salary.
Current salary.
Please, Lord, because that is something the court has been every time saying, though at least Lordship will pass an order to release our current salary.
Within a week or whenever it's.
And
Already file is before
these
your lordship.
people are working in a non-sanction phase.
Yeah.
Moment they will come into sanction post, it will be released, my lord. Lord say another hardly 15 days, everything will be out in the open, my lord. That tabulation is being last days going on, then the appointment order will
We
be.
are hearing the same submission for the last 6 months. They came with the thing that first the model conduct, code of conduct is there, then something else. What is going on now?
Tabulation.
So let Lordship will give them 2 weeks.
Verification is complete.
Tabulation of.
Tabulation of this 314 and all other person will get it on all this tabulation. Final stage of tabulation is going on.
Lordship may keep it, he is saying 15 days, let them, Lordship may say within 1 month, release the salary, let that be effective order. He says he'll take them 15 days, so Lordship will give him 4 weeks, but within.
To sanction order, my lord. Lordship will post it after 15 August. In the meantime, everything will be done. Yes.
Lordship will say it's a human, Lordship, I don't need to re-emphasize the fact that it's a human issue here. And Lordship has itself noted. Oh, okay.
So there will be positive direction to release the salary.
Praying for a positive direction, at least salaries, the current salaries may be released. Lordship.
And the date, by the.
Lordship also note these people are working in a non-sanction post. As on date.
We may be sanctioned or non-sanctioned, but the fact is we are discharging our duties. That he doesn't say. He is taking free service for last 10 years. That they don't say. Be fair to the court.
But also want them to implement.
They have to get the
Be
money for
fair to the court.
to get the money to they have to get the sanction. That is where we had many.
Okay, I'll pass the order in the IA. Very well. And then I'll give you one month time to release current salary.
Lordship will post it after 15, but in the meantime, the tabulation will be over. Order of post of the sanction order, all things will be over. The appointment will come on in the
We'll
meantime.
release it after 1 month.
The moment that sanction is ordered, then we can release it, my lord.
So that's why I'm giving you one month time.
Lordship will post it after 15th of August.
No, I'm not posting it after 15. I'm posting it after. No, I'm posting it after 1 month.
Lordship.
And within the 1 month, by that time you can get it.
All that.
Within the 1 month, they'll complete the formalities and release our salary, Lordship, current salary. That observation may be given, Lordship. In the IA, who are the parties?
In our case, the IA has been filed.
Huh?
In our case, the IA has been filed.
By whom?
By the.
You filed how many IA?
Implement law.
One IA only.
Yeah, one line. 682.
6020, isn't that?
682 petition.
TJ Montessori is appearing in this case. TJ Montessori is appearing in that case, that's it.
Yes, yes.
And 21.
1 minute.
21.
You are assisting him?
Yes, that's it. Item 21.
MS.
Add the bill, that's it.
And the parties?
Ganesh.
Respondent list?
Turbo Nursery versus
Dahar.
Dahar Nursery versus Ganesh Nursery.
Ganesh. Here for the petitioner logic. And they are for implement in the
1 minute.
as respondent.
You are the petitioner.
Yes, that's a for Ganesh Nursery and others.
Respondent, 1, 2.
For all the petitioners, that's it.
No, that's me.
1 to 127.
No. Gutulen is 121.
Mm-hmm. Oh, I.
117.
Mm.
Correct. Assam Elementary. Kedas. Just write it down. TJ Manda. No, Ken Chowdhury, assisted by?
Yes, does.
S does, learn counsel for the applicant. Then TJ Manda, assisted by Ms. RDV, for respondent 1 to 1 117. MSK does, then it's standing counsel elementary education for respondent 118.
Yes, state of Assam represented by the Commission Secretary for Elementary Education. 118, no, respondent.
118.
118, it will be 100, definitely.
And you are?
I am for respondent number
Okay, for us.
121, 122, 123, 124,
1 minute.
125, 126.
Respondent?
121 to 128. No, yes, 120.
121 to
128.
and finance go. Respondent 119. WBT and BC.
Hard.
120.
Hard. 120. Respondent 120. Okay. I'll pass orders. Or I'll just reserve it and give the judgment. The IA.
We are appearing item 31, 32, 33, 35.
No, in the IA though, you are not appearing.
I am appearing now. We are vehemently opposing the IA. What they have done is they have filed the
IA main respondent is the TJ Manda.
Yes.
Yes.
Correct. That has been
Number
filed in his
21.
writ petition.
True, but effect is across to everyone.
No, that's fine. That's fine.
So we are opposing.
That's fine.
So Lordship may take note of what I had submitted because ultimately they have filed it in one writ petition, but it affects all of us.
Okay.
All right.
Great.
2011. That is, he's junior to the petitioner by about 16 years. Now on 9/12/2017, your lordship, 26, there was a government notification whereby 26 LP schools in Karimganj district were merged with another 26 LP schools. So the petitioner school was merged with that of the respondent number 6. Now, your lordship, on 30 January 2024, the headmaster of that school, she was supposed to retire. Accordingly, an order was issued at page 16, lordship will catch, whereby the director of district elementary education officer directed the petitioner to take over the in charge headmaster being the senior most teacher. May I read your lordship? Consequent upon the retirement of Srimati Suprava Dharpal, head teacher 23 now, Dalwachan Khani LP school under BO RK Nagar, Sri Sushil Chandra Das, the petitioner here in your lordship, senior most assistant teacher of the said school, is hereby allowed to take over the charge of head teacher cum member secretary of the SMC of the school temporarily with effect from the date of taking over of the charge. So being the senior most, your lordship, that was the order. But before he could take over the charge, at page 17, your lordship will get, another order was issued by the block elementary education officer, whereby he had given the charge to respondent number 6. And that was prior to her on 25/1/2024. With reference to the subject cited above, I have the honor to inform you that the head teacher as member secretary of that school has already been relieved, and in that place, working teacher of the aforesaid school, Vikas Lal Sinha, is hereby allowed to act as head teacher. So the district elementary education officer issued an order in my favor, and a direct violation of the order, another order by the block elementary education officer, giving the respondent number 6 the charge of head teacher. So when this matter came to my knowledge, I immediately made a representation to the block elementary education officer, informing him about the order passed by the district elementary education officer at page number 19. Lordship has got it, your lordship. So after getting that order, the BO on the letter pad itself had written at below bottom, lordship will see, Vikas Lal Sinha, assistant teacher, is hereby intimated to, as per to act as per the order of District Elementary Education Officer Karimganj and strictly intimate for compliance accordingly. But then also he did not relieve the post, your lordship, and ultimately the DO has to issue an order at page 21 to the said respondent number 6. Lordship has got it. This is by the District Elementary Education Officer to the respondent number 6. With reference to the subject cited above, it is reported that you have not handed over the charges of head teacher of so-and-so school to the senior most teacher of the school, Sri Sushil Chandra Das, and above. This you have refused to do, being a junior teacher. Now you are instructed to hand over the charge of head teacher of the school to Sri Sushil Chandra Das within 5 days. Even after that, your lordship, he was not handing over the charge. So I made again a representation to the DO at page number 22. And after getting that or this representation, the DO assured that he will take appropriate action against the respondent number 6. But in the meantime, your lordship, I was not aware, and the impugn order was passed at page number 25. 24 is a typed copy, your lordship. May I read, your lordship? Whereas Srimati Pompi Das, SMC President, and 162 others of the locality guardians, parents of students of 23 Nong Dalwa LP School alleged against Sushil Chandra Das, senior most teacher of 23 Nong Dalwa LP School, in charge head teacher cum member secretary of the said school, stating that the teaching method as well as the behavior of Sushil Chandra Das is not satisfactory. Whereas the guardians, parents, well-wishers of the said school demanded to allow Sri Bikaslal Sinha, assistant teacher, to act as in-charge head teacher, as his method is appreciable and a well-behaved one, replacing Sri Sushil Chandra Das. Considering the facts of the allegation and for the interest of education as well as the school-going children, the order issued by the office number, the initial order, your lordship, is hereby cancelled, and simultaneously Sri Bikaslal Sinha, assistant teacher of the said school, is allowed to act as in-charge head teacher, your lordship.
Yes.
Completely behind the back, your lordship. These allegations, neither I know about any such allegation. Nothing and not shockers. Nothing was given to me, and this order was issued on the basis of a frivolous allegation that some students and guardians have made, your lordship. Such a baseless allegations cannot be a ground to deny me from the post of serving as in-charge head teacher, your lordship, being senior most.
I'll issue notice. You want notice because the other party is a party.
Yes, yes.
Private party is there, isn't there?
Notice may be issued, your lordship, and impugn order may be stayed, your.
That is too late now.
Yes.
But Mr. M.H. Laskar, let the council issue notice. M.S. Infukan, done standing council. Elementary Education Department appears for respondents 1, 2, 3, 4, 3 and 4. 1 to 4. Correct. You don't have the read petition.
It is 22. 1, 2, 3 and 4, my lord.
1 to 4. Petitioner to take steps for service of notice on respondents 5 and 6 by registered post AD within 1 week from today. Respondents are allowed to file affidavit. On top, we will just put the extra copies. List after 4 weeks. The
Impugn order shall be subject to outcome of the writ petition. That
the order dated 11/3/2024, by which the respondent number 6 is allowed to act as headmaster, isn't it?
headmaster in charge.
Headmaster in charge of 23 number WLP school shall be subject to the outcome of the suit.
Any date, your lordship, otherwise matter may not. After 4 weeks, a date may
It
be.
will come up. Initial notice.
Oblige, lordship.
20.
May I please, lordship? Now, the petitioner herein is the senior most assistant teacher of the school.
Now, on the basis of the graduation list was prepared. And the principal who was in the school, he going to be retired. So before that, the graduation list is forwarded to the director of secondary education. Now I am figured as number one, being senior most teacher. I having all the qualification as per the Provincialization Act 2018. Now, while the director of secondary education by this impugn order rejected my candidature on the ground that I have not obtained prior permission while I am pursuing my Master of Arts in Assamese. That was the ground alone on the basis of which the respondent number 4 herein, who was on the gradation list figured as serial number 4, was appointed as a principal in charge, which is absolutely in derogation of an order of this passed by this honorable court. This honorable court on 2023, Lordship on 28/9/2023, held in Mosumi Shaharia case that Rule 13 will not applicable or put in embargo while considering the selection of a candidate. It may constitute to be a misconduct, but cannot be said to be an embargo legal impediment. Lordship, kindly have a look. To one-page order. Paragraph 4, Lordship. After 5 lines, it starts from but. But however, we take note of the Rule 13 of the Rules 1965 is a rule framed under the Assam's such and such, meaning thereby that a violation of any provision thereof would have to be construed to be a misconduct. If the act of the writ petitioner would have to be construed to be a misconduct under the Rule 1965, the appropriate remedy would be to initiate disciplinary proceeding against the person for having committed such and such. But a misconduct of such nature of having obtained a degree from a university without obtaining permission cannot lead to a conclusion that the degree obtained from a university itself is untenable in law. An university offers a degree in exercise of the powers under Section 22 of the University Grant Commission Act, such and such. Taking note of Rule 21 of the General Clauses Act, it is only the university who can declare the degree obtained to be untenable in law or may withdraw it. No third party can be understood to have any jurisdiction or authority not to accept a degree offered a university in exercise of the power. Now, similarly, in the terms of this Shaharia case, another judgment of the same bench, Lordship will find the second judgment I have relied upon. Lordship, kindly have a look at paragraph 3. Paragraph 3. The implication under the law of obtaining BA degree without obtaining prior permission had been decided by this court in his judgment dated such and such, Srimati Mosumi Shaharia versus such and such. In Mosumi Shaharia, a proposition had been laid down that if a government employee obtain an educational degree from a board of university without obtaining prior permission from the appointing authority under Rule 13 of the Rules 1965, it will be constituted to be a misconduct. But such misconduct cannot be rendered a degree otherwise valid in law, awarded by a board or such and such be invalid. Now, 4 is the conclusion. From such point of view, the order dated such and such of the Director of Secondary Education Assam in refusing to take into consideration the B.Ed degree of the petitioner as because it was obtained without obtaining prior permission from the appointing authority would unacceptable in law. Now, Lordship, kindly have a look, the order, the impugn order. It is absolutely in sheer violation of the law laid down by this honorable court. Lordship will find at page 31 at page 32. I obtained from through the RTI. Second paragraph. On examination of the seniority list, it appears that the first enlisted teacher, Srimati Mamuni Gogoi, this is a petitioner hearing, MA B.Ed assistant teacher received a graduate scale of up to 3/1/1994, and she has obtained MA degree while in service without prior permission from the appointing authority, which is found to be in violation of Clause 13 of Assam Civil Service Conduct Rules 1965. Therefore, my candidature that was not considered. And before obtaining MA degree, I'm duly intimated to the IS, my appointing authority, through the principal, and principal forwarded the same. Lordship will find that letter at page 29. No, sorry. At page 27. Lordship will find in the bottom that my application dated 28/6/2016 was forwarded by the then principal.
Yes.
May I please, Your Lordship? Here, Your Lordship, I would like to take you to the impugn order, that is Annexure 8, page 32, where it was clearly mentioned that second paragraph, on examination of the senior list, I would like to read, Your Lordship. It appears that the first enlisted teacher, Srimati Mamuni Gogoi, who is the present petitioner, MA, BA, assistant teacher, received graduate scale of pay with effects 3/1/1994, and she has obtained MA degree 2018 while in service without prior permission from the appointing authority, which is found to be in violation of clause 13, Your Lordship. Now I would like to take you directly to that service rule, Assam Civil Service Conduct Rule 1965.
There is prohibition,
13.
nothing to be repeating. There is a
13.
prohibition. There no government service.
Let me complete, Your Lordship. No government servant while in government, shall join or attend any educational institution for the purpose of preparing himself for or shall appear at any examination of a recognized board or university without obtaining previous permission from the appointing authority. Because, Your Lordship, here it is clearly mentioned what is the rules, Your Lordship, and here on Assam service rule, Your Lordship, it is civil service rule. It was clearly mentioned that she has violated the provision of section 13, Your Lordship. So my prayer at this stage, Your Lordship, is may go.
My learned sister would not understand the judgment pronounced by this honorable court.
Okay.
That issue has been already been delivered by this honorable court.
But Mr.
B. Datta.
B. Datta, senior counsel, assisted by Mr.
Yes, Decca.
S.
Decca.
Decca, learning counsel for petition. Issue notice. MS B. Das, in the standing counsel, secondary education department. Appears for respondents, 1 to 3. Extra copies. Petitioner to take steps for service of notice on respond number 4 by registered post ID within 1 week. List of performance.
The impugn order may be
The
stated.
interim. The order dated 21/6/2024. Issued by the Director, Secondary Education, Assam, shall remain suspended.
And because the inspector of school may take the charge of the.
Let them work out their own.
Yes, Lordship.
It's not the court work.
Lodge. Grateful.
Item 98 to 102, order.
Yes, my lord. I beg an indulgence, my lord. My lord, before my learned senior starts, I like to place some records before the court so that interdiagram what has happened that the court can then. So, my lord, item number 99. Pradyum Dikshit, petition number 676. You take out 1 for order. Where is 1 for order? Where is 1 for order? 676. Item number 100, my lord. Kumar Gaurav, WPC 879/2024. And Adesh Kumar Patra,
WBC number 881 of 2024, item number 101, N. Yashraj Burma, WBC 91935 of 2024. My lord, it is my humble submission that, my lord, this 4 matters by the virtue of a document which has been placed before this honorable court has become infructuous. Now, let me give the context here, my lord. If Protein Dixit petition replies where our
Yes.
Yes, my lord. So my lord will just, for a reference, my lord will take up Pradyum Dixit's writ petition's reply. There is our order dated 1/4/2024 is there. Just to apprise this honorable court.
One.
That is Pradyum Dixit, WBC 676 of 2024, item number 99, my lord. In the item number 99, in the affidavit in opposition which we have filed, there is an order at page 72 to 73.
Page
72 to 73, my lord. That order is there.
Yes.
So my lord will remember this. This has come to my lord's notice. I tried to. In this case, what has happened, my lord? This is similarly an alcoholic sort of a party that created a rampage both inside the campus and outside the campus. And there was an affray. Thereafter, what has SDC had happened, BOG had happened, and before the court had passed an order on 14/3/2024, my lord. And by that order, the court had asked IIT to relook the matter. After relooking, my lord, this order was passed by the IIT authorities. In all the cases, all 16 cases. So as per that order, my lord, at 1/4/2024 order, that is appearing in page number 72, my lord, the last point 4, you are directed to submit an undertaking signed by you and your parents, stating that you will abide by the institute rules at all times. Now, my lord, once this undertaking has been submitted by these 4 petitioners, Pradyum Dixit, item number 99, Kumar Gaurav, item number 100, Adesh Kumar Patra and Yashraj Verma, by their parents. To my understanding, my lord, this petitions does not require any further adjudication by this honorable court. The only issue which will arise now, my lord, is this. They have approached IIT to allow them to sit in the exam classes, which is starting from day after tomorrow. That's from 24. Now, if this court continues to, then there will be again, they have not allowed, you give me another IA, another EA, then this creates an multiple. Once these people have submitted their undertakings, this honorable court can dispose of these matters and separate item number 98. Let that 98 be agitated by the petitioner. I have nothing to say on this. But 99 to 102 becomes infructuous, my lord. That is my only submission. I am just bringing this. If he wants to contest, my arguments are ready. Then I will praise the argument. But because of this undertaking, which is come in interagram, this I humbly submit that this may not be, my lord, further prosecuted, and writ petitions can be closed, my lord.
Yes.
My lord, may I see the undertaking? It is there. You have attached it, no? In your with your rejoinder itself, you have attached. In the rejoinder reply which you have filed, that is your undertaking is attached.
Attached the undertaking, I have attached the format of undertaking.
Same as pilot thing.
In that undertaking, we have never said that we are guilty. In the only they have taken, they wanted to take undertaking that you will not violate rules and regulations, etc. So that undertaking has been given, that we are not going to violate rules and regulations, etc. So that is the undertaking, my lord. My lord, you see that undertaking does not say that we have accepted the decision of the SDC. That is not the undertaking.
No, my lord, I'll show the records.
Well, let me see.
No.
We get undertaking. Can I get a copy?
It is there
of a document you have produced before the court? Can I get a copy?
That is part of your record also.
That is not part of my record.
I'll
I have
show you
not.
that it
I
is
am
part
not
of your
submitted any undertaking.
My lord, they
If
have,
it is not, I'll give the undertaking, my lord. No
they
problem.
have
Let him come.
producing something before court, but not giving. the
I'll
copy.
give the copy, my lord. No problem. If I have given the
Let
code, I'll
it
give
be
it.
given to me.
No problem, my lord. No. Sanjay, show me that.
He is submitting that petitions have become in
What is that,
but at the
first
same time, he is not giving copy to me.
Wait, no. First, wait, show me that mails which are there. Give me the mails.
Have you filed your reply?
I have filed the reply.
When?
My favorite reply is, my lord.
When did you file your reply?
Reply, I think reply should be in
Not
the,
in record, that's why I'm asking you.
my lord, first item, my lord, item number 98.
Hmm.
The reply is with the record, my lord. Item 98. Reply.
Okay, no, I'm on
We can start with item 98, my lord.
99, I'm on 99.
99, I cannot say whether it has reached or not. Yes. Of course, we have taken permission to bring this. My lord, may kindly see.
These items, my lord, maybe first, if my learned senior doesn't have the copy, I will give it. No problem.
Let
sir.
me, I have
Because
no,
this-
I don't have the copy. No? That
These
is why I'm,
documents have not come from me, my lord. This is-
No,
I am asking for
what
the
is the
copy now.
problem?
Why
I will give you my only have a one copy, I will give it.
why so much hesitant?
You can see and then give it back. So, my lord, there was a mail, so it is not coming this way. There were communications before.
My lord, what is this? This, my lord. For which is being roll over such and such enrolled student in IIT is a permanent resident of such and such. Boy number is there. Keep as a permanent. Acha. Do have undertake on this the 18th day of July 24 that I was never involved in any act of indiscipline earlier and will not indulge in some same while inside or outside the institute campus.
Show me this.
I've never instituted. Hereby acknowledge that I shall be liable for expulsion forthwith from the institute on being found involved or in committing any offense cognizable or punishable under the ordinance on code of conduct of students. Moreover, hereafter, if violence any rules, regulations, I shall be accept any punishment imposed upon me. So where is the admission? Where I say that I am accepting the punishment imposed by them? Nothing. Only that, and clearly, I was never involved in any act of indiscipline earlier and will not indulge in any same.
This is a format prepared by you?
Yes.
Yes, madam. This undertaking has been taken in line of this order of 1/4/2024. And those who have accepted the order, they have filed the undertaking by both the parents. So once you accept the order and file the undertaking, to my understanding, my lord, then this writ petition doesn't require any further adjudication. That is my understanding, my lord, and I will show that how the order is coming to picture. This undertaking is coming to picture. There were mails first.
I'm very sorry.
Complete, my lord.
Right by the experiments.
There were, after this order has been passed, there was an, my lord, in para number 3, it has been written that since the IIT follows continuous evaluation process, the last line, my lord, the further support may be extended to take additional courses and to compensate and complete the program at an earliest possible. So in line of that, there were emails being sent after this.
They are in their which semester?
Now, some of the students are in third year, to my understanding, my lord. Only fourth, I think only the response in item number 98 is in the fourth year. That's not in the third year. So mails were sent by the IIT that your expulsion is, this is the order been passed to you. There is an undertaking supposed to be given. You come and you register and you start with your classes. So that mail they have responded and given this undertaking. So once the undertaking has been given by them, my lord, they have accepted the order of 1/4/2024. And if the order of 1/4/2024 is accepted, then this writ petitions become infructuous.
My lord, how I cannot understand what type of submissions are being made. What is this undertaking? Can't by any stretch of imagination we can say that by this undertaking I have accepted the order of the SDC. In this undertaking, I said I have never indulged in any indiscipline.
Have you consulted your client?
Yes, my client has consulted by me yesterday itself. He said no. We have never acceded to the punishment. We never agreed to it. So all matters may be heard in merit. How can, my lord, they said that 1/4/2023 order. Where is 1/4/23 order? It said that this undertaking is required and because of this undertaking, merit 1/4/23 order is matter. Annexure number 1A, page 72 of their reply.
I'm on that page.
my lord. So in this,
Look at that condition number 4.
my lord, you are directed to submit an undertaking signed by you and your parents stating that you will abide by all the institute rules and regulations. So that is different thing. But whether this undertaking says that I have accepted this letter dated 1/4/24. My lord, some students are given some on meal that you are to sign this undertaking, you sign this undertaking, he has signed this undertaking, but he never said that I am, whether there is a format of undertaking and here with my lord. No format.
No, do you
If
have,
this, no, no, if this,
do you have specific instructions
my
to
lord,
continue with the case?
yes, my lord. Yes, my lord.
Are you sure?
Yes, my lord. Yes, my lord. Yesterday itself, I have talked to my clients. Yesterday, I have told to my lord.
Then what is this undertaking?
My lord, this undertaking is that only I have never indulged in any incident and I shall always abide by the rules and regulations. That is simple. My lord, in this, my lord, this page number 72, they have never mentioned what type of undertaking they made it. If the undertaking would have been that, I am agreeing to the terms and conditions as mentioned in letter dated 1/4/24. That would have been different thing. We have never agreed to this terms and conditions. We have never agreed to this. And in fact, in our affidavit, my lord, we have submitted our affidavit, my lord. Today itself, affidavit in file, my lord. We have denied.
1 minute.
We have disputed this letter dated 1/4/24, my lord.
This to the court and then the court will take care of.
We have disputed it. It is, my lord, 18/7. Undertaking that in 18/7. But affidavit has been filed yesterday or today itself, I think.
Please give it to the court, my lord.
All these are disputed, my lord. In our affidavit in reply, my lord, we have specifically mentioned that this we are not agreeing to letter dated 1/4/24. They specifically mentioned there.
Find out those mails.
We have specifically said in our affidavit that we are disputing the letter dated 1/4/24. We are not agreeing to it, and we dispute it. We challenge it.
Find out no other copies are there.
My lord will see the mail which I have submitted. My
1
lord.
minute, 1 minute.
So they want to turn the matter in different way. My lord, if in the undertaking it would have been mentioned that we agreed to your letter dated 1/4/24, definitely my client would have not signed it. If in the undertaking it would have been mentioned that we agreed to STC decision and we agreed to BOC decision and we agreed to this letter dated 1/4/24.
Have you given all the documents, undertakings? There?
It is there. My lord.
Have you given him all the undertaking?
My lord, the undertakings which I have.
The undertakings are not identical.
Some of them, because they have made certain changes by hand.
No, no, by type.
They have made certain changes by
This
themselves.
case, Yashras Verma.
I also just received it in the morning, my lord. I also have to go through it. That is the reason I was, because these documents were given. I will also have to see that those documents again. I do not have an extra copy, my lord. I have to see what. So, my lord, if my lord will see that mail, my lord, for a moment, that mail which I have handed over. By that mail, this undertaking was circulated to them by the Student Affairs Department. And maybe I'm not sure what is I will not comment upon the instructions part, my lord. But my instructions are this, my lord, that the students have accepted. And that is the reason they have given the undertaking.
They have to enroll.
My lord,
Have
they have to enroll again, my lord.
Have you done it?
The process will start from 24th itself.
For enrollment?
For taking classes and other things, enrollment, taking EA. Because IIT also wanted to close to an extent. Those who have accepted, they are closing the matter and proceeding with the case.
My specific instructions are that they have not accepted the penalty imposed by them, and
they have not
accepted the letter date of 1/4/24. They have not accepted the letter date of 1/4/24, my lord. My specific instructions are there, and to that effect, we have filed affidavit also, my lord. Affidavit has been filed. I think it is submitted today itself. So this letter is 18/7. Affidavit is filed today. So we have not accepted it. How can it become fructuous on the basis of these undertakings?
Show him this copy.
I've shown him.
You given him only one copy.
Yes,
isn't
my
it?
lord. I only had.
Regularization.
The court is asking me to see them.
You read that page, which I
Which are court being free.
Yeah, ma'am.
not that next page.
Yes, Raj. Yes, Raj. Ma'am. My lord. Yes, Raj. Ma'am.
What does it say?
My lord, she says that I agree that I shall not violate any terms and conditions, any rules and regulations of the institution. And
Last paragraph.
yes, my lord. I acknowledge that I have submitted following documents during commencement of academic registration and shall not violate any rules and regulations and conduct myself under parental guidance in institute campus for the remaining period of my study.
That means he has accepted it.
My lord. He says that, my
Are
lord.
you under proper instructions?
Yes, my lord. Yes, my lord. Yes, my lord. Yesterday, the student came to me in my chamber. Yesterday, he came to me from in my chamber from his native village from UP. He came to my chamber. And yesterday, he has signed affidavit in my chamber saying that he is aggrieved by the order of the STC and he wants to take a contest. Yesterday, he came to my chamber. He signed the affidavit, ma'am. And in fact, this
My lord,
person,
on that
this
case-
person, yes, in fact, my lord, this person, yes, Raj Verma, his case is very difficult, very different. He was not present to the incidents. They said that it has happened on 2 days, 8/8/23 and 12/8/23. This student was not even present on 8/8/23. He boarded train from his native village and reached the institute on 12/8/23. He reached the institute at evening 7, around 7. He
If
reached
the
the institute.
submission is on merit, my lord, then I'll submit. I am just
Yes.
holding back my submission, my lord, because this is on the undertaking issue is something which has just come to me.
Have you shown them the undertaking that they have given you?
Today I have received from them. If you are not, then my lord.
Problem is you have also not printed out all the copies properly.
It just came to me also, my lord. In the morning, it came to me that this is the, so they have given in the last night or something that these things have happened. This is because
No, when you print out the court's copy, you could have done it for him also.
we will do it. We'll give a copy to the him and let us. My lord, apart if this point is this that they can take instruction on the undertaking.
That's what I'm saying.
Yes, my lord. They can take the instruction on
You
undertaking.
can take instructions on the undertaking.
All right, my lord, I can, but one item is then item number 98. That can be taken today.
What's the point of taking it?
My
up
lord,
in the first place?
each case is different, my lord.
Each case may be
Each case is
different.
different, my lord. Item 9, they say that in item 98, there is no undertaking. They say that in 98, there is no undertaking. And each and every case is different. Each case has to be taken differently. Each someone has noted at all involved. Some maybe slightly some involvement we seen, but in some cases there is no at all involvement. So all cases are different on merit. All cases has to be taken differently. One hearing will not be sufficient for all cases. All cases are taken to be differently. So if that is
Then
so,
why is it clubbed up together?
that should not have been. But since it are IIT matters, so that is why they have clubbed together. Actually, there is no need of clubbing together. All matters are different. Hearing has to be taken separately, my lord. So if they want to say that other matters, all right, I shall take instruction. But regarding the 98, they say that regarding 98, there is no undertaking.
My lord,
So we can take up
with
this.
regard to 98, my lord, I have something to say. Once my learned, let me just point it out. This rejoinder in the IA has been filed, it's been given to me during the court hours. So there is no IA, but the
there are new cases, new
In
facts have been.
item number
99, my lord, 98, my lord.
98.
Yes, my lord. They have filed a rejoinder in the IA.
Yes, Sharma.
Yes, my lord. In the rejoinder, they have stated some new facts, which are in the personal knowledge. I do not know whether
What is
he is,
this? What is this IA?
his IA is to allow him to, he has not given those examinations, my lord. And he is asking that you pass me. I have not given the examinations.
That is not,
declare
that
the
is not,
result and we pass
that
me.
is not, that is not, that is absolutely absurd.
Rejoinder, where's the rejoinder?
It is
It's been
absurd.
given to me today only.
My lord,
I think
entire,
today in the-
my lord, entire case has to be taken. Not only IA.
No, fine. Where's the rejoinder in your IA?
Hmm?
It's not coming.
My lord, let it be taken on Thursday, my lord. It's because
I would take your some more time, my lord, to file an affidavit because I have to file an affidavit.
oh,
in this.
again they
This
will
is-
file affidavit.
My lord,
Again they will.
he
That,
will
that
continue
cannot
to
be.
say
That
one
cannot be
minute.
allowed, my lord. That cannot be allowed, my lord.
my lord, I'll tell you what is being said.
That
in this.
cannot be done, my
He
lord.
has said that the professor has thrown his application and thrown away. He has made a specific statement in the IA. He is saying that I have attended the classes and you have marked me absent because of a malafide and malice allegation. How I, being representing the institute, I can respond to malafide and malice allegation, my lord? In a writ code, how can I do that? I have to take instruction properly, my lord. I have not interrupted. Let me, because this professor has thrown the application and thrown away. It's a very serious allegation. He has said that his application has been thrown away. He was going to he has given the professor application to allow him to give the exam. They did not do it, thrown away. Then there is a malafide allegation, malice allegation. How can I, while representing the institute, answer to this, my lord? I require some time to file in this affidavit, my lord. In item number 98, I may be given that. Similarly,
again,
in the rejoinder also, my lord.
Again, my lord, deleted tactics. Again, deleted tactics. My lord, they know that.
See.
My lord.
Your rejoinder affidavit is not before this court also.
My lord, that is why.
When did you file it?
Let it be taken at.
When did you file the rejoinder affidavit?
Today morning is.
How can it be here?
All right, my lord. It can let it come on
my lord.
Thursday. In the meantime, they will submit whatever affidavit they want to submit. No, my lord, because my lord, the registration are starting for 24th and without fine, and with fine it will be by 30th. Then if the matter is further delayed, again they will come with technical fees. The time of registration is expired, so you come again after 1 year. So another year will be spoiled.
If he is successful, this honorable court has power to direct IIT to.
That is different thing. That is different thing. That is different. But regarding classes, my lord, regarding attending classes, my lord, I have recording, my lord. In the courtroom, they have stated in the courtroom that only 2% did not attend the classes. Regarding yes, Sharma, they said yes, Sharma stated the class. I have recording. I have downloaded recording from the court proceedings, my lord. That was there, my lord. They have themselves that yes, Sharma. They did not say that yes, Sharma did not attend classes, my lord. They said 2% yes, Raj and others. These two people did not attend classes. No, yes, Raj not attended classes.
Record is there, my lord. Who has attended classes and who has not attended classes. Those records have been brought by IIT.
Regarding 2 persons, they said that did not attend classes. Adesh Patra and another Kumar Gaurav. In 25th 4, they submitted before the court that out of 4 persons, 2 persons, namely Adesh Kumar Patra and Kumar Gaurav, did not attend class. That is why there is a specific submission before this honorable court, and I have from court streaming, I have downloaded it. It can be presented before the court. They are changing their versions. They are changing their versions. On one day say that yes, Sharma has attended class. Now they say want to say no, he did not attend the class. Because why? They did not take my attendance, my lord. Because I was not registered.
My lord, these are all in.
Yes.
I do not want to respond in this manner, but
they have responded.
I'll not indulge into this, my lord.
You filed rejoinder in item number 98.
98, my lord.
You want to file
yes, I have to file an affidavit because otherwise this position it is not known to me.
New ground has been taken.
New ground has been taken. Not only this rejoinder in the IA, rejoinder to the writ petition, they have taken a new ground of malafide. And other grounds have been taken to say that no.
This, which writ petition?
In the 98, my lord, and probably in this rejoinder also in this rejoinder also, same grounds will be taken by them. And let me clarify this, my lord. Whatever has been stated, nothing can surprise the record.
In writ petition, we have always stated malafides.
My lord, the records are clear that this guy has not attended classes. Let me be very categorical to this. Then maybe I do not know what my learned senior is referring. I will not respond to that. But record of IIT is absolutely clear. This gentleman has not attended classes. I have the record before me with me now. I can take this honorable court through.
Whatever they are doing with their records, we do not know. We have attended classes and they have admitted before the court.
Let
They have admitted before the court. Whatever they are doing with their records, we do not know. We do not know whatever they are doing with their records. But we have attended classes and they have admitted before the court on 25/4/24. They have admitted before the court.
Yeah, that is don't worry, one the matter will follow the next.
Yes, I can show the video recording.
1 minute. No point in.
They have gone to the extent of my relationship with some girls also. They have came to that extent also. And they want to say that we have brought new facts.
What is this affidavit?
My lord, which one is?
24.
Which my lord is referring?
No, your reply affidavit is not here.
My affidavit reply should be there. It was on last occasion. Affidavit reply.
Your reply affidavit in the
writ
item
petition.
number 98.
98.
In the IA,
Well,
it is
except
not
this
there.
one.
In the writ petition, it is there. Writ petition, it is there. But in the IA, it is not there.
In the IN, it is not there. In I may not be there. In writ petition, it is there.
Yeah, that is
In the
there.
writ petition, it is there. In the writ petition, it is there.
Okay.
So let it be given a short date, my lord. Let it come on Thursday, my lord. Considering the matter, urgency of the matter, let it come on Thursday, my lord.
When is the last date for the admission?
That is, my lord, with fine 24, without fine 24, with fine 30.
30.
30.
Then you'll have to expedite.
Lord, I will assist this honorable court.
We'll take it up on Friday.
My lord, please.
We'll try to get it. Mr. Sharma, learned counsel for the applicant. In IA number 1980 of 2024. Submits that he has filed an affidavit in reply to this morning. Registry to verify and place the same on record. He found in order. List the matter, list these matters again on 26th July. In the meantime, what you can do, you can check up with your clients,
Sure.
with the petitioners.
Sure, sir.
With regard to the, I've given back that.
Yes, my lord. But in this case, my lord, if the 99 and 100 and 101 and 102 have been separated, my lord, then, or if the instruction is to, for their side to, that they have not accepted, then probably, as they have been saying, that this matter has to be separated and individual hearings to be done.
Hearing may be individually. Let all the cases come on that day. Let all the cases come on that day. That is.
I'm not overriding my. My lord, I'm just because these rejoinders I have not, this rejoinder I have not seen. What they have said in this rejoinder today, which they have filed. I also have to see what is there, what is there. So that consideration maybe, my lord, be taken. On that day, then they will say something, this video has been said, this video. Because sometimes, my lord, what happens? The instructions are over the phone, are not sometimes clear. We are also, petitioner may jump up and put some word in our mouth and say, no, you've admitted to this. No. Yes, Sharma has not attended any classes. And categorical records have been there before this honorable court.
Categorically said that.
Across that, my lord. Nothing. Even though if there's an admission, that admission is beyond the instruction.
Okay.
I categorically say that. Yes, sir, my attended classes. We can prove it.
Meantime, you take appropriate instructions.
Deeply obliged, my lord.
If they've given the acknowledgement, in other words, they are accepting the letter.
To my knowledge, they have not. Still, I shall ask further, clarify.
No, it's not up to your knowledge. It is.
No. To my instructions, up to my instructions, they have not accepted it. To my instructions, they have not accepted. Further, I shall take further instructions by showing.
My lord, advocate here that the student should lose. That is what is my.
They are worrying about the students' loss. They have taken such illegal actions, and now they are worrying about the students' losses. I cannot understand it.
87. Admission.
No, sir.
What is 87 again? Yes.
Matters pertains to non-issue of my lord NOC to the pharmacy college of the petitioners. Petitioner is well, my lord, your lordship is well aware that the petitioners run different educational institutions, including the University of Science and Technology, Meghalaya, my lord. And what? And this is one of their institute at Karimganj district at Bodarpur. They have established in the year, my lord, 2019, and their first application is, my lord, page number 37. Page number 37 is their first application of 2019. They have established the school, college, my lord, pharmacy college. And during pendency of this, my lord, application, the Pharmacy Council of India, page number 38, the Pharmacy Council of India, the statutory, my lord, body, which approves the colleges, my lord, issued this approval, my lord, on 10th of April 2020, page 39. And the concerned university is the Sivanto Sankardev University, my lord, page number 40, also, my lord, issued affiliation to the college, my lord, dated 17/8/2020. That is this.
No. What is this?
Number one.
What is this 37?
37, my lord. 37 is the application, my lord, for issuing NOC by the state government. NOC is a, my lord, one-time measure. It is an NOC, my lord, like a building permission or like an individual, my lord, anything, my lord, where the state government's permission is required, my lord, to establish an institute, my lord. The state government will see the feasibility, whether it is required or not. And these are the, this is not the infrastructural requirement. What will be the infrastructure? What will be the, my lord, the teaching or non-teaching faculty? These are not the concern of the state government. The state government will issue the NOC to establish, my lord, to start a college. So during pendency of the NOC from the state government, the Pharmacy Council of India and the, my lord, the concerned Sankardev University issued, my lord, affiliation and approval for starting the courses, my lord.
No. Just page 37, come to that.
Yes, my lord.
Come to page 37.
Yes, my lord. This is the.
Read the last paragraph.
Yes, my lord. Sir, a no objection certificate from the state government is a prerequisite for submission of application of to Pharmacy Council of India. The online portal for the approval of application has opened on the 15th of November 2019 and will close 15th of December 2019. In this regards, we would request you authority to kindly issue a no objection certificate to start a new college.
So you are saying they have not given you the no objection certificate?
Yes, my lord.
Then how did you make your application before the Pharmacy Council of India?
Yes, my lord. There is, my lord, the Pharmacy Council of India can issue, my lord, the approval and affiliation also, my lord, subject to the, my lord, subject to the obtaining of the NOC, my lord. There is no bar, my lord. They can be applied, but it is issued subject to the, my lord, NOC issued by the state government.
So what did the Pharmacy Council of India do?
They issued the approval, my lord, and the university also the given the affiliation, my lord, to start the courses, my lord. Accordingly, my lord, what happened, my lord, on 3/6, my lord, 3/6 page number 54, the state government issued NOC, my lord. They have issued NOC, my lord, page number 54, but only for 2 years, my lord. Page number 54. Since, my lord, the students were admitted for the 2 batches, my lord, 2020-21 and 21-22, my lord, page number 54. Page number 54, my lord. This is the
1 minute.
Issuing department, my lord.
Yes.
Page number 54. The Medical Education and Research Department. This is the, my lord, department which issue the NOC, my lord. So this is the NOC for starting degree and diploma in pharmacy course in private institute as applied for. With reference to the letter on the subject cited above, I am directed to convey no objection of the government of Assam in Medical Education Research Department, starting degree diploma in pharmacy course at the following institute for the admitted batches 2021. Since the two batches already admitted and they are undergoing, and subject to the condition that no further admission for the session 22-23 and thereafter shall be made by the institute without government permission, they shall submit undertaking to this effect. Non-compliance of the order can cancellation of this no objection certificate. So, number one is the petitioner's college. Number one, and these two colleges were issued NOC. Now, my lord, this condition that without permission cannot take admission, this condition was challenged before this honorable court, my lord, in earlier round of litigation, because there is no provision for yearly NOC, my lord, for issuing yearly NOC, since they have issued for 2 academic, my lord, year. That was not, my lord, it is a one-time measure, my lord. And
how do you know that?
My lord, this is because in other colleges, my lord, in other colleges where similar, my lord, NOC was issued, they have been subsequently issued, my lord, permanent NOC, my lord, page number 68. Other private colleges which were issued the similar, my lord, NOC, page number 68, your lordship will find. Page number 68, my lord.
Yes.
NOC for starting degree diploma in pharmacy courses, NEF college. This is one of the private college, my lord. I have annexed. With reference to letters on the subject cited above, I am directed to convey no objection of the government of Assam in Medical Education Research Department for starting degree diploma in pharmacy course to NEF college, pharmacy education from session 22-23 onwards. Onwards, my lord. It is one time, my lord. NOC is one time. That this was like this order, the initial order should have been passed, my lord, from 2021 onwards. But, my lord, do not know why this is only 2 academic years were issued, my lord. So, my lord, this honorable court, my lord, your lordship's one judgment in earlier round of education order is page number 76, my lord. In earlier round of education, my lord.
76.
76. From 74, it starts, my lord.
1 minute.
74. It was an interim order, my lord, in earlier round of litigation. I have also annexed the final order, my lord. Page number 74. Your lordship order starts from page number 76. The same issue was there, my lord. So after going through the my lord record, page number 77, Mr. Gogoi, my lord, page number 5, paragraph number 5, may I read my 2 paragraph, my lord? Mr. Gogoi, Understanding Council Health Department, on the other hand, submits that unless an application is made in earlier round of application, my lord, they had taken a view that we have not applied, my lord. Application made paying NOC, the state respondents would not be in a position to grant NOC. He also submits that the other institutions had already made application for grant of NOC, and it was on the ground that NOC was issued to those institutions for admission to 22-23 sessions onwards. After hearing the learned counsel for the parties in the interim, it is directed that the government health department shall consider issuing NOC to the petitioners college. However, subject to the condition that the petitioners college cooperate giving information for the requirement made by the authorities in the health department by maintaining parity with other institutions that have been issued NOC. It is made clear that in the event authorities in the health department requiring information from the petitioner shall provide same. Let a decision be respondent be taken within 2 weeks from today. But, my lord, there was no decision was taken. That, my lord, the final order, my lord. There was also another order, page number 80. Earlier, my lord, interim order, your lordship's order was there. That order was not complied with. Then your lordship had passed another order, page number 80, my lord.
80.
80, my lord. Your lordship's order, that was, my lord. My lord, pursuant to the order dated 22/6/23, that is earlier orders your lordship mentioned, passed by this court in the present petition directing the government health department to consider issuing NOC to the petitioners college, namely so and so. The respondent number 3 has filed an additional affidavit so and so, wherein it is stated that as there are certain deficiencies mentioned in the inspection report in respect of so and so pharmacy college, Badalpur, government is not in a position to issue NOC petition institute for the year 22-23 onwards. A perusal of the documents enclosed in the said additional affidavit clearly indicates that a decision of the government not to issue NOC was based on an inspection report 21 to 22. It would have been prudent on the part of the health department to have had a fresh inspection prior to taking a decision. In that view of the matter, the authorities in the health department are directed to have a fresh inspection of so-and-so pharmacy college for within a period of 2 weeks. Thereafter, take a fresh decision for issuance of the NOC Petition Institute. Let the inspection report and the decision of the health department be placed by way of an affidavit.
This is the same petitioner.
Same petitioner, my lord.
Then what happened?
Then, my lord.
What happened to these cases?
Yes, my lord. Then the final judgment, my lord, the inspection was there, my lord. Inspection report, your lordship's inspection report as per your lordship's order is, I have annexed, my lord. There is only one deficiency is mentioned, my lord, in the next page, my lord, the inspection report, my lord. Page number 82, my lord. With due honor and reference to the subject cited above, please find here the inspection report, so-and-so college in connection with the NOC for starting diploma and B Farm and D Farm regarding checklist laid down Pharmacy Council of India. We are submitting report along with the annexure so-and-so. This is also informing that principal so-and-so has given assurance that he will complete 3 laboratories with all requirement, the teaching staff room and an auditorium within 3 months. Then, my lord, the details checklist is there, and my lord, page number 86 was the regarding the laboratory. Page number 86, serial number 2. Page number 86, serial number 2. Regarding the laboratory area, my lord, there was the laboratory space was, my lord, some short, my lord, area was, my lord, smaller than the required area, mentioned in remarks column, my lord. And based on this inspection report, my lord, this honorable court passed the final, my lord, order, my lord, page number 90, by disposing the writ petition, my lord.
Page 90.
Yes, my lord. On the basis of this report, my lord, the relevant operative part is, my lord, page number 94. From 93, it starts, my lord, from 93. Paragraph number 5, may I read, my lord? Paragraph number 4, may I read, my lord? A reading of the inspection report dated 12/8/23, as well as the initial NOC 3622, makes it discernible that the laboratories that is existing in the petitioner's college is found to be smaller in dimension than what is required, but some further rooms are available in the building. In other words, the petitioner authorities, if they intend to do, can utilize the further available space for being converted into laboratories so that the dimension of the laboratory is to be satisfaction of the respondent in the medical education department. In view of the aforesaid factual aspect as discernible from the NOC as well as the inspection report 12/23, we are unable to agree with the prayer of the petitioner that in spite of not having NOC, they be allowed to admit students for the next academic year, which have been prevented by respondents in the medical education department, or else to issue a direction to the medical education department to issue NOC to the petitioner. The original NOC 3x22 is explicit in itself that 1 year had been granted to the petitioner institute to engage the dimension of the laboratory, as well as it is also an admitted position that the further space is also available within the building of the petitioner college. So what further remains is to desire on the part of the petitioner to utilize the further space available for the purpose of the laboratory. In view of the above, the authorities in the petitioner to approach the commissioner and secretary to the government of Assam in the medical education and research department to have a precise information as to what is required to be done and to what extent the dimension of the laboratories are to be extended, and as extra space is already available, necessary modification be done to the building so that the laboratory or acceptable dimension are put in place. The authorities in the petitioner may forthwith approach the commissioner and secretary to the government of Assam in the medical education research department, and upon doing the needful, may make the necessary modification in the building, and upon completion of the same, to make a representation to the Commissioner Secretary for the immediate inspection of the space that may be modified, and the Commissioner Secretary shall do the needful to pass a reasoned order within a period of 7 days from such communication after the modification. So there was an order of a fresh inspection, my lord, and which is done, my lord, as per the direction of the authority, my lord. The order is at page number 10T and 102, my lord, for fresh inspection. In pursuance of the order passed by the Honorable Court, 102, my lord. Order by the department for fresh inspection, my lord.
Yes.
Pursuant to the order passed by the Honorable High Court, dated so and so, and decision of the meeting dated so and so, chaired by so and so, department, so and so, my lord, with the following officers hereby directed to reinspect the college or the pharmacy Bodalpur to verify whether the authority so and so pharmacy has fulfilled the deficiency shortcoming as indicated in the various inspection report regarding the issue of conduct of the B Farm course. So a fresh inspection conducted, but the report is not furnished to the petitioners, my lord. But what was the report? It is in their impugned order, my lord. So may I first go to the impugned order, my lord, where it is rejected, my lord. Page number 116, the impugned order. So, my lord, in the first page 116, my lord, regarding the case and all this is mentioned, my lord. And in the second page, first paragraph with the order of the Honorable Court mentioned, my lord. And second paragraph is important, my lord, where the inspection report is mentioned, my lord. Whereas the DME Assam submitted an inspection report dated 2010-23. This is the last inspection, my lord, of Allama TR College of Pharmacy, Badarpur, Karimganj, wherein DME means, my lord, Director of Medical Education has opined that Allama TR College of Pharmacy has fulfilled all the required infrastructure facilities to start degree and diploma in pharmacy course as per norms, and God may kindly consider to issue NOC to the TR College of Pharmacy to conduct D Farm and B Farm courses. However, it was also mentioned that Government in the Medical Research Department by order dated 31/21 had imposed a moratorium on opening of new pharmacy institutes temporarily till a new regulatory framework for pharmacy education in the state is notified by the government. Whereas the department notified a new regulatory framework on nursing, pharmacy, elite health science in order to streamline health science in the state with approval Honorable Cabinet 7th November 2023. Whereas all new as well as old government and private pharmacy institute would now come under the purview of the regulatory norms in order to ensure the education. Whereas all application of pharmacy courses under private and university would have to apply fresh in compliance to norms of given by the regulatory framework. In view of the above, after careful examination of the case, the Government in Medical Education Department hereby regrets its inability to grant permission in respect to the petitioners to NOC. So, my lord, this Honorable Court's clear direction was there that after inspection, the particular deficiency was mentioned that the laboratory space, we will modify it and approach the authority, and the authority will conduct an inspection and pass the reasoned order. In the inspection report, my lord, no deficiencies. They are in earlier round of litigation, my lord. I have, my lord, placed the record that their contention was that they are in the inspection report, there are deficiencies, my lord. In the repeated order of your lordship's order was there of inspection, my lord. Conducted the inspection, deficiencies met, my lord, but they have come with a fresh ground that the new framework is, my lord, issued. Now, my lord, your lordship, I will bring 105 is the new framework, my lord. The new framework is, my lord, for opening a new institute, my lord, not for existing institute, my lord. Page number 105. 105, my lord, regulatory framework subject of the nursing, pharmacy, and elite courses. In the realm of the health education department, number of institutes of both government and private sector have been set up. Public health care. It has been felt necessary to streamline institutes, nursing, pharmacy, elite science course, as there is a wide variation standard of this institute in physical infrastructure, human, so and so. Therefore, with a view to develop nursing, pharmacy, elite health science, education state of Assam and to bring them up to all India standard, graduates, diploma holders in nursing, pharmacy, and elite health science courses, Government of Assam has framed, well, this is important, that detailed norms in regard to physical infrastructure, academics, teaching facilities, etc., my lord, for opening new nursing, pharmacy college, elite health science. This is important, my lord, for opening new institute. This regulation is, my lord, issued, my lord. Our institute, my lord, 19 established 2020, already, my lord, NOC issued 21, 2021, 21, already NOC issued, students admitted, they are, my lord, undergoing the course, my lord. So the issue, my lord, the main issue in this writ petition, my lord, to be decided, my lord, is whether the petitioner's institute is a new institute, my lord, and will fall under this notification, or is an existing institute, my lord. My lord, my humble submission is that, my lord, that our institute is a new, is an existing institute, my lord, and this notification, my lord, page number 106, my lord, 106, second page, my lord. Procedure, my lord, Roman 2, in the middle, my lord. Heading, my lord, procedure for applying for new nursing, pharmacy, and elite health science. So, my lord, those institute which, my lord, will start, my lord, has not started, my lord, their course. This notification is for them, my lord. And all the procedure, my lord, under this heading, my lord, is for a new pharmacy, my lord, which have not started the courses, my lord. We are going, my lord, from the 2021, 22, my lord, with the statutory body's approval, my lord, affiliation of the center, my lord, of the concerned university, my lord. And, my lord, your lordship will come, this notification, page number 111. This framework, my lord. Page 111. There is a provision for existing colleges, my lord. Roman 13, my lord. Existing government and private nursing, pharmacy, and health science institution, Assam. All existing institutes having obtained no objection certificates from the Government of Assam offering health education in Assam are required to ensure full compliance with the aforementioned norms within a period of 2 years from the date of this notification, following which NOC certificate would be reviewed. So we have been, my lord, issued 2 years NOC, my lord, already. So how we come, my lord, under this notification, my lord, for opening a fresh institute, my lord. We are running our courses, my lord. This is the issue, my lord, and my lord, this honorable court, my lord, the other pharmacy colleges, my lord, which have been issued the NOC, my lord, they have been issued, my lord. I have brought your lordship's, my lord, notice that they have been issued permanent NOC, my lord, subsequently. Page 68, my lord. Page 68, my lord. They have been treated, my lord, existing colleges. And before that, my lord, your lordship may come page number 62. 62, my lord. These colleges with the similar condition, my lord, issued the NOC. Page number 62, my lord. These private colleges, my lord. NEF college, NIPEDS, and regional institute, my lord, 1, 2, 3. These are permanent colleges, my lord. Issued NOC, my lord. Page number 63. Same NOC, my lord, which was issued to the petitioner. Page number 63, may I read, my lord? These private colleges, page number 63. With reference to the letter cited, I am directed to say the government of Assam in medical and research department issues no objection certificate, degree and diploma courses following institutes 2021 and 21-22, subject to the condition that no further admission for the session 2023 and thereafter shall be made by the institute without government permission. So the same order, my lord, which was, my lord, issued to the petitioners, my lord, institute. Petitioner's order is page number 54. 54 and 62, my lord, same order, same wording is there, my lord. 54 and 62, my lord. Kindly, my lord, come to 54, my lord. Same order, my lord. I have read my petitioner's college order, my lord. 54 and 62. The 63 is the same order, my lord, with the same condition to the private colleges. And my lord, 60. 62 and my lord 54, same order, my lord, with the same condition was issued.
Yes.
23. Now, my lord, page 68, my lord. Page 68, my lord. They have been given the final NOC, my lord. 60, 68, 68, my lord. 68, my lord.
Yes.
So this is a discrimination, my lord. Earlier round of, my lord, litigation, this issue was raised, my lord, that there is a discrimination, my lord. The other private colleges, my lord, they were also issued the same order, but my lord, subsequently, page 62, they have been given the, my lord, final NOC onwards, my lord, page number 62. Page number 68, my lord, final NOC issued.
Yes.
For the session 22-23 onwards, page number 68. So that is the discrimination, my lord. And my page number 70, my lord, in an RTI replied, my lord, they have admitted, my lord, page number 70, reply to the RTI, my lord, as per records of the department, following NOC have been issued for starting private pharmacy courses for the year 22-23, 21-22, 22-23. My lord, these private colleges are there. And last is the petitioner's name for the year only 2021 and 22-23. 2021-22. In the first round of litigation, my lord, they had pleaded that we have not applied, my lord. But from 2019, our application is pending, my lord. And also they have in this petition, my lord, they have in their affidavit, my lord, in opposition, my lord, your lordship may come to page number 126, my lord. First affidavit in opposition, my lord, for their plea. In earlier plea was that, my lord, that we have not applied, that we have deficiencies. All this is met, my lord. Now page number 126. In this case, affidavit in opposition, my lord, what was there?
126.
126, my lord.
Respondent number 4.
4, my lord. Page number 127, next page, my lord, paragraph number 5. In every occasion, they bring a fresh plea, my lord, an excuse to deprive the petitioner, my lord. Page paragraph number 5. As the statement made so and so, the opponent state that the petitioner established science college prior to 2020 without NOC from state government. 6. The statement made in paragraph so and so admitted next one 7. As the statement made in paragraph 8, petitioner, paragraph 8, my lord, that as regards statement made in paragraph 9, so and so, without obtaining NOC, the government and started, my lord, without obtaining NOC, that is, my lord, subsequently issued NOC, my lord, for the 2 admitted batch. So by retrospective effect, they, my lord, issued the NOC. Accordingly, considering the career of the admitted students, medical department issued NOC, so and so, my lord. Now, my lord, paragraph number 10. That inspection report was forwarded to the government, so and so. In the letter date, so and so, the deficiency mentioned, my lord. But what is subsequently, my lord, there was no deficiency mentioned by the inspection department, my lord. So in subsequent paragraph, my lord, they have mentioned regarding the deficiencies, my lord, which have been, my lord, cured, my lord, in the last My lord, now, my lord, paragraph number 15, my lord.
What was para 11?
My lord, para 11, my lord, 5 pharmacy is on the basis of the applications and necessary verification, etc. However, God was not positioned to consider NOC of the petitioner matter of sub judice. So now is a fresh plea is that our case of sub judice before this honorable court. That was the new plea, my lord. In earlier occasion, my lord, that was not a plea. Earlier occasion was that we have not applied, but our application was pending, my lord, and that deficiency was there. So deficiency is cleared, my lord, no deficiency. Now the plea is that our case was sub judice before the honorable court. This is a new plea, my lord, not in earlier occasion, my lord. Now, my lord, paragraph number 15, my lord. Regarding this, my lord, new framework, my lord. Regarding new framework 7/11/23, framework of the nursing and allied health science, as a result, had expressed inability consider NOC to the petitioner college pharmacy, instead submit fresh application, my lord. Accordingly, petitioner college submitted a fresh application. My lord, no fresh application is submitted, my lord. We have submitted an application, my lord, regarding our, my lord, pending. It is a reminder application, my lord. No fresh application submitted, my lord. Our existing college is existing, my lord. Though it is mentioned, my lord, we have filed a reply, my lord, that our application, my lord, we have annexed. Page number. No, last application. Page number 119. 119, this is our application, my lord. There is no mention of any fresh application as per guideline 119, my lord. 119. This is an earlier application, my lord. We have earlier filed. There is no mention that we have come under the new framework and we have as earlier applications, my lord, the similar application as a reminder, we have, my lord, filed this application, my lord. So, my lord, this is the application.
Pharmacy council has given you the.
Yes, my lord. Even 23-24 is given, my lord, pharmacy council. But we could not take the admission because of the NOC, my lord. The pharmacy council and the university, my lord. The pharmacy council given, my lord. There is no deficiency, my lord. They have inspected the college, my lord. No infrastructural deficiency, my lord. Nothing is there, my lord. But what is the reasons best known to the department, my lord? In every occasion, they bring a new plea, my lord. For the last 2 years, it is a private institute, my lord. For the last 2 academic sessions, they could not take admission, for which it is, my lord, financial burden to pay the salary of the staffs and the, my lord, infrastructure facilities. It is a clear case of discrimination, my lord. The similar colleges have been, my lord, issued NOC, and the petitioner is deprived, my lord. Repeated order of this honorable court is there, my lord. Your lordship's order is there, my lord. Final order is there, that after fulfilling the all deficiencies, my lord, they passed an order that there is a framework, my lord. And regarding, my lord, the one, my lord, plea was there was a moratorium, my lord, but the moratorium was not applicable in case of Northeast, my lord. I have annexed the copy of the, my lord.
Where is that?
Moratorium. Oh, first.
So where's the moratorium? Where is the?
Yes, my lord.
Notification?
Page number 46.
40?
My lord. My lord, page number 120, my lord. No moratorium is there, my lord, but there was a mention of that there was moratorium for which they could not issue. 120, my lord. The Pharmacy Council of India notification 17 July 2019 regarding moratorium, my lord, the northeastern states was an exception, my lord. 17 July 2019, page number 120. Relevant is resolution page number 122, my lord. Yes, my lord. 122, my lord. It starts from 120 and 122 is the resolution. My lord, may I read? Taking into consideration the availability of sufficient qualified pharmacists Workforce, the House unanimously resolved to put moratorium on the opening of new pharmacy colleges for running diploma as well as degree courses in pharmacy for a period of 5 years from 2021. This moratorium shall not be applicable in northeastern region of the country where there is shortage of pharmacy colleges. So, my lord, Pharmacy Council of India exempted this region, my lord, where there is, my lord, shortage of pharmacy colleges, my lord. And my lord, even though the state government, my lord, issued any moratorium, my lord, before issuing the NOC, my lord, then how the private institutes have been issued, my lord, page number 68. How the private institutes issued on 22-23, my lord, page number 68.
Where is that moratorium again?
Page number 68, I will show my lord, your lordship, that this is order is passed on 20 February 23, my lord. And the framework came, my lord, 7/11/23. My lord, page number 105 is the new framework. And there was an plea that before the framework, 7/11/23 is the framework. The plea was that the moratorium will be till the framework of the new framework 7/11/23. But how this 68, page number 68, 20 February 23, before the notification of 7/11, page number 105. Yes, madam. 105 is the yes, well, 7/11/23 is the notification, my lord, framework, new framework. And my lord, February 23, page 68 is the NOC issued to other private colleges, my lord.
Before this one came.
Yes, my lord. Before this, my lord, issued, but there was a my lord plea in the notification that an moratorium was in existence, my lord. Page number.
Where is that moratorium?
Yes. Well, it is mentioned in page number 117, my lord. 117 regarding the moratorium mentioned, my lord, in the impugned order. Second paragraph. However, it was also mentioned that government in medical education department by number so and so had imposed a moratorium on opening new pharmacy institute till a new regulatory framework for pharmacy education in the state is notified. So, my lord, the framework is notified on 7/11, and my lord, on February 23, they have issued NOC to the other pharmacy colleges, private pharmacy colleges.
No, 1 minute.
It is contradictory, my lord. Once they
7/11.
7/11/23 is the new framework came, my lord.
So before the other college.
Yes.
That was done in 20 February.
Yes,
2023.
23. Yes, my lord.
So this is before the moratorium came in, before the new framework came in.
Yes, my lord. What is, my lord? It is 21, from 21 to, my lord, 7/11/23. The moratorium from 21, your lordship. I will read, my lord, page number 117. However, it is also mentioned, paragraph 2, in medical education department by order dated 31/21, my lord. It starts.
Where is this order?
Yes, my lord. This order, my lord, is not, my lord, with me, but my lord, it is also mentioned in earlier, in my lord, application, DME letter, page number 42 is also mentioned, my lord. Page number 42, letter of the Director of Medical Education, Assam, dated 7/4/21. Page 42, my lord. So, as per
42.
yes, my lord, page 42. It is a letter of the DME, my lord, on the basis of our application, my lord. After filing of our application, the Director of Medical Education wrote this letter, my lord, to the Principal Secretary. Issuance of NOC to the Petitioners College, my lord. Subject, with reference to the subject cited above, I have the honor to forward here with an application along with DPR submitted by the chairman, ERD Foundation, connection with NOC to the pharmacy college. It is to be mentioned here that by the government letter dated 31/21, government has imposed moratorium in opening new institute temporarily till a new regulatory framework education framework for pharmacy education in the state is notified by the government. So the moratorium from 31/1/21, my lord.
Where's this letter?
My lord, this letter is not available to the petitioners, my lord.
No, you have a copy?
No, my lord. No, right now I don't have the copy.
You'll have to produce this.
Yes, my lord. I
They will be on the basis of this only the.
Yes, my lord. I can obtain the letter.
My lord, if it is, my lord, for the sake of argument, it is held, my lord, is there, that's the argument, then how, my lord, it will applicable from 31/21 to 7/11, my lord? Because framework came on 7/11/23, from 31/1/21 to 7/11, it will be effective, my lord. Then how the private colleges, my lord, issued NOC page number 68, my lord, in February 23, page number 68, my lord. February 23, my lord. It will be effective till a new educational framework, that is on 7/11, my lord. The new framework came 7/11/23, and these institutes have been issued NOC on February 2023, my lord.
This is a new institution?
Yes, my lord. In the same footing, my lord. Same NOC for the 2 years issued to the.
This NEF college?
Yes, NEF college, my lord.
College I've seen somewhere else. also.
Yes, my lord. Same NOC issued to the NEF college, my lord. Page number 54, my lord.
Page 63, 62.
Yes, 62, yes. And 54 is the first NOC, my lord, to NEF college. JB college, my lord. One is JB college. And 62 is the 62 is number 1 NEF, number 2 NIPETS, number 3 Regional Pharmacy. 62, my lord. Page 62, number 1, and the 63 is the NOC, my lord. It was the first NOC, and then 68, my lord. The final NOC during the moratorium period, my lord.
Get a letter, copy of the letter or order. It is in one, it is said letter, in the other, the final one, it is said order of 31/1/2021.
My lord, page number 71. Is there, my lord. Seventy 71, my lord, regarding issue of the NOC during this moratorium period, my lord. 71 to other private colleges. 20 February 2023, my lord. So the moratorium period is from 21 to November 23. And this NOC issued February 23, my lord. to other colleges.
No, including yours.
No, my lord, for only my lord, 2 years, my lord. 20,
That's right.
it is my lord earlier issue.
21, 22.
Earlier issued, my lord, not this date, my lord. It is 22 issued, my lord. But my lord, as per Pharmacy Council of India, there could not be, my lord, moratorium, my lord. This is a statutory body, my lord. My humble submission is that, my lord, in the present, my lord, the petition, the issue is that whether my college is an existing or a new, my lord. If I am an existing institute, my lord, I do not come under this framework. NOC should be issued, my lord, to me like other institutes, my lord. And if it is a new college, my lord, this honorable court, if held, my lord, that is a new college, then, my lord, I will come under the framework. This is the only issue, my lord. My humble submission, my lord.
You get a copy of that letter.
My lord, I will get the copy, but I would like to point out one thing, my lord. My lord, because initially, my lord, the conditional NOC that was issued to the petitioner, my lord, that was issued considering the career prospect of the students who were admitted without obtaining the NOC, my lord. Because the petitioner institute admitted students, my lord, and thereafter they applied for NOC. So considering the future of the students only, my lord, conditional NOC was granted, my lord. So that NOC cannot be treated and they cannot claim that it is not a new institution, my lord. Because without obtaining NOC, my lord, they admitted the student. So government was kind enough to, for the sake of the future of those candidates, my lord, admitted students, the government granted NOC. And secondly, my lord, in my affidavit, I have stated that, my lord, now the petitioner has applied fresh, my lord. They have submitted EOI, expression of interest, my lord, in terms of this new framework, my lord, new regulation dated 7/11/2023. Now, my lord, there is a recent development, my lord. If your lordship takes up the new regulatory framework dated 7/11/2023, my lord. There, my lord.
Page 105.
Huh?
Page 105.
Page 105. If your lordship comes to page 113, my lord. The annexer A to that guideline, my lord, which stipulates minimum standard requirements. Page 113. So, in clause number 4, my lord, the requirement is that, my lord, 4B, my lord, for allied health sciences pharmacy institute. The institute applying for opening new allied health science pharmacy institution must have a 100-bedded teaching hospital with X-ray clinic with radiology, ultrasound, CT scan facilities, and NABL accredited lab, or the institute should have a MOU with a government hospital, not below the level of district headquarter hospital for a specific period not less than 5 years. The number of institutes to be tied up with the government hospital will be regulated as per section 10. So, my lord, the petitioner institute, while conducting the earlier 2 batches of students, my lord, probably at that point of time, they executed a MOU with the Karimganj Civil Hospital. Now, my lord, after their application, now we have come to know that, my lord, that MOU has been cancelled, my lord. So they have not fulfilled the terms and conditions of this notification. Your lordship, recently, my lord, on 12/7/2024, that MOU has been cancelled, my lord, because that MOU was executed by the concerned superintendent without obtaining approval from the government.
Have you given them a copy?
Yes, my lord.
My lord, before going to this, my lord, second line of the page number 113, my lord. Page number 113, the second line, my lord. The detailed norms of regarding physical infrastructure, teaching facility, etc., for opening new pharmacy college. So this minimum standard for new pharmacy college, my lord. This is, my lord, maybe taken note into.
Second page, my lord, that has been communicated to the petitioner institute, my lord.
The MOU has been cancelled.
Yes,
My lord, that may be, my lord, but if it is a new institute, my lord,
no, my lord.
minimum standard requirement, my lord, page number 13 is opening new institute, my lord. So
My lord,
my
assuming that it is not a new institute, kindly come to page 64. Because the NOC that has been issued to other institute that he has relied on, my lord, there is also this condition is there, is also there, my lord. The NOC issued to 3 other institutes, my lord, which starts at page 62, my lord. There, my lord, page 64. The institute will furnish an agreement with the affiliated parent hospital for.
You are reading from?
My lord, page 62 is the.
No, no, I've seen it. I'm on page 64.
Page 64.
Which para?
Para 6, my lord. The institute will furnish an agreement with the affiliated parent hospital for clinical exposure as required, with all clearly state that such an arrangement will not access to institute. So, my lord, anyways, my lord, for conducting the pharmacy course, my lord, they need a MOU or agreement with her.
Why was it cancelled?
Because that has been cancelled by the health department, my lord. So I have to obtain, my lord, why it has been cancelled. But after all, it has been cancelled. Now they do not have any MOU with any civil.
No, who cancelled the MOU?
The joint direct MOU, my lord. Because I have received this communication, my lord. It has been cancelled by the joint director of health services, Koringganj, my lord. Joint director of health.
Now, how can you just cancel like this?
My lord, they can challenge that cancellation, my lord.
No, 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 that is not the way to do things. Maybe they can challenge it, that's a different thing.
And how
can you how can you just cancel an MOU by a joint director?
No, my lord, how it has been cancelled, I have to obtain
These things you should have the instruction.
Yes, my lord, that I can obtain. But after all, my lord, at this stage, my lord, they do not have any MOU with any hospital, my lord. So they have not fulfilled the required criteria.
Okay, take them.
My lord, in every occasion, a new plea is taken. My lord, my humble submission is that, my lord, this petition, my lord, may be decided, my lord, on the issue that whether our college is an existing or a new, my lord. Only this will, my lord.
Let us get that letter first.
Yes, my lord. And my lord, I have another, my lord, submission is there, my lord. Already page number 4145, my lord. Then educational notification is already issued, my lord, for this academic year, page number 1145. The university, my lord, concerned university for taking admission, all the colleges, common entrance examination, my lord, page number 145. And already entrance is, my lord, taken, result is given, my lord, and admission process started, my lord. So this year we will also be deprived of, my lord, for taking admission, my lord. Earlier 2 occasions we have lost 2 academic years, my lord. This is the university notification, my lord, already started the academic session. They have taken the, my lord, 23/6/24, page number 15 was the date of the exam, my lord, June 23. So if this year is lost, my lord, then the college will have to be, my lord, shut down, my lord, because of the financial crisis, my lord. Page 147, my lord, other private institutes, my lord, issued, my lord, the advertisement and already started, my lord, the process of admitting students, my lord. So if my friend is taken stand, my lord, the matter may be fixed day after tomorrow or on Thursday, my lord. Very urgent, my lord.
Otherwise, also in the absence of the MOU with a civil hospital, they cannot start the course, my lord.
Yeah.
They cannot start, my lord.
Have you got a copy of this?
Yes, my lord, I have, my lord.
But Mr. MG Kati is going counsel for the petition. Mr. DP Vora, the responding counsel, health department, has produced a communication dated 12 January 2024.
12 July.
Written by
12 July.
written by the Joint Director of Health Services.
12 July.
Yeah, 12 July. And addressed to the Director of Health Services Assam, wherein it is stated that the memorandum of understanding signed between the Alama TR College of Pharmacy, Patarpur, District Karimganj, and the Karimganj Civil Hospital, Karimganj. This is on 12/1/2024 only.
12 July. My.
12 July.
No.
Oh, yes, ma'am.
Huh?
12 July, my lord.
12 July.
No, 12 July is a different thing.
It is last.
The MOU signed on
12/1.
Yes, my lord. Maybe, my lord.
is 12/1/2024 is signed. Bara. Mr. D.P. Bora, the Standing Council Health Department, shall take instructions as to on what basis the said MOU was cancelled. Stop. The Learned Standing Council shall also produce a copy of the order dated order number HLD, stop 442 oblique 2020 oblique 592 dated 31/1/2021, which is reflected in the notification dated 17/11/2023, issued by the Commissioner and Secretary to the Government of Assam, Medical Education and Research Department by the next alternate date. Stop. When shall we have it? Friday, Thursday?
Thursday, maybe. My.
Friday, my lord.
And it may come as a part hard.
Is the matter again on 26th July. I'm not keeping as parted, you can upgrade it like.
Public.
Oblige.
63 admission.
Matter partners were non-grant of child care leave. In fact, child care leave was granted, but she was not allowed to resume her duties, after availing the child care leave for 2 years, as per your lordship's direction, dated 2/8/2022, passed in the 2/8/2022.
Yes.
The petitioner, had approached the principal, but she, was not allowed to resume her duties, In this case, the director of secondary edition filed an affidavit, they are saying that since the petitioner, is a contractual employee, so, she is not entitled to child care leave, and their leave is counted on the pro rata basis, 2.5 days per 30 days, In fact, our honorable court says there is a decision, judgment of this honorable court, It is equally covered, Kindly, have a look.
Who appears on the other side?
I am appearing. Second line.
In this matter, we have filed our affidavit here, my lord. And my lord. Here, my lord, page 40.
It is squarely covered by Dolly Gogoi case,
Page?
Page 40 in our affidavit.
Page 40?
And the last paragraph.
So many pages. Which para you are referring to?
However, from the verification of report dated 5/11/2018.
No, para number.
Para number 4.
Para 4.
Para 4. And last line, however, from the verification of report dated 5/11/2018, received from the principal of Sajani Kanta Higher Secondary School, Borpeta, it was found that after completion her medical leave 11/3/2014 to 7/6/2014 for 90 days without pay, the petitioner was again granted leave on medical ground as well as maternity leave with effect from 8/6/2014 to 10/11/2016 and child care leave with effect from 2/1/2016 to 17/12/2017 by the president of the Managing Development Committee of the said school, which was extended at the interval of 90 days from time to time by various orders. However, no copies of such orders were forwarded to the inspector of school BDC, Borpeta. Moreover, the principal of the said school, while letter dated 15/11/2018 stated that Mr. Mohanlal Das, president of School Management and Development Committee of the said school, had alone granted the above mentioned child care leave to the petitioner without any resolution of School Management and Development Committee. Moreover, my lord, in our affidavit paragraph 5, here it is for the contractual agreement. It is stated that agreement model from contractual and engagement of teachers as per government notification by so and so dated 10/6/2020. In point number 7, it is stated that the party will be entitled to a leave on a pro rata basis of 2.5 days per month. Period which leave is to be taken should be agreed with the president of SMC. Leave not available during the month shall lapse after the month is over. Further, there was no such provision for child care and maternity leave during 2014 to 2017 for the contractual employees working under the secondary education department. Moreover, my lord, here in the after my lord, moreover, it is also mentioned that here that the connection in connection to the honorable court order dated 2/8/2022, the inspector of school BDC Borpeta Bhaidit's letter dated 30/3/2024 stated that the petitioner did not communicate or did not go to the principal to join her post after the expiry of her leave. And moreover, my lord, in the repetition, one notification is annexed in Annex LP, page 37. Annex LP, page 37.
Child care leave notification.
Clause 9. The child care leave shall not be demanded as a matter of right and under no circumstances can be employed proceed on a child care leave without prior permission of leave by the competent authority. So here, my lord, she has not got any permission from the competent authority.
Who's the competent authority?
Competent authority is School Management Committee.
And my letter.
So the president of the SMC granted this leave.
But there was no resolution at all. Only president knows that.
Maybe there was no reason, but can you blame it on the petitioner then? Petitioner was granted leave by the principal, so he went. No, not by the president. So she went on leave.
And
without any resolution, without any official.
That part is there. That part is there that there was no resolution as such. Is the petitioner to be blamed for that? She requested for child care leave. She requested for childcare leave, the president granted the childcare leave, so petitioner proceeded.
And moreover, my lord, one wrong submission has been made, my lord, in the affidavit, my lord. They had said that after obtaining that order, my lord, I did not approach the principal, my lord. Now kindly come to my affidavit reply, my lord, page 67, my lord. Now, my lord, principal can do this, my lord. It is Bhanagula, my lord, page 67, kindly see that, my lord, left side, my lord. It is duly received by the principal, my lord. Bhanagula part, my lord, bottom, my lord.
67 is a different page for me. This is the High Court order.
It is. Thereafter, my lord, the submission, my lord. And vernacular is also there, my lord. That in the vernacular page, my lord, the principal of that himself received that letter, my lord.
Where's the vernacular?
To the principal Sajini Kant, my lord, dated 5/8/2022, my lord. There, my lord. That was duly, my lord, and that leave, my lord, that was, my lord, interpreted already, had interpreted by our honorable court, my lord. I have supplied, my lord, on Dolly Gowe case, my lord. That is equally covered, my lord. Here, my lord, this case is also, my lord, on contractual employee, my lord. Paragraph 14 onwards, my lord. This people exist.
Yes. If you got a copy of this.
Moreover, honorable FS court also said, my lord, that women employment, whether permanent or temporary, my lord, they cannot be deprived from the, my lord, leave, my lord, maternity law, childcare leave, my lord. And it is a beneficial provision, my lord.
You study that case and come back. We'll list it next week.
Yes.
We'll dispose it of.
Yes.
I think it's a clear case.
My lord, already
But yes,
2018.
Mark, Learned Council for the petition on request made by Mr. Yu Shah. Learned Standing Council,
Secondary Education Department.
when do you want?
Next week, man.
31st.
Article.
My lord. Oblige me.
64.
Oh.
May I please, your lordship, I am appearing on behalf of Harvey Bora from BTC. This letter has been segregated from the earlier series We need some time to take instruction for further.
2019 matter.
Yes, my lord, they have already filed one affidavit, my lord. They now want from up to date instruction, my lord.
When did you file your affidavit?
Affidavit, they have filed, my lord. In any ways, my lordship may fix it another next week, my lord. They can have up to date instruction. my
Okay,
lord.
heard, Mr.
Yes, doctor.
S. Dutta, then the counsel for the petitioner on request made on behalf of S. Bora. Then
RB Bora.
RB Bora, then standing counsel,
BTC.
BTC. List the matter again on, when do you want?
2 weeks. That's it.
List the matter after 2 weeks.
Date may be fixed, my lord.
To enable her, list the matter okay, on 9th August,
Right.
My lord, I'm for,
to enable her to receive instructions. Huh?
I'm for, on behalf of Ardhar, WPPC, respondent 120.
Respondent?
120. It is there in the order, my lord.
Huh? Respondent?
My lord, on the last order, it is 120, the Commissioner and Secretary, WPT and BC Department.
Order date?
This is order dated.
Series of affidavit.
This is,
Earlier, the matter was tagged with another series, maybe is referring to that order.
yes, with that series of, sorry. Since our name is reflected in the first list.
Our done standing council WBT. Department appears for respond number 7.
Oblige.
65. May I pray, my lord? In this case, no affidavit has been filed on behalf of Higher Education Department.
Lordship. Is it conducted by the Lordship? It's some time required, it's not get the instruction, Lordship. Then this time, although several times.
Mr. A. Bhattacharya, then council on request made on behalf of Mr. D. Upamania,
no.
then the standing council higher
Higher
education. How much time? 2 weeks.
10 days, 2 weeks.
2 weeks time is allowed to file contract.
Can it date be fixed, my lord?
List on 12th August.
8. Oblige.
66.
This was substantially heard, my lord. I pray that may be taken up on a hearing date. Mr. Gogoi appears.
Proceed from it. I have no objection. I'm ready, Lordship.
On request made by departments. When do you want? Give a date. Or
I'm always in. Immediately.
Any Tuesday or Thursday, my lord, as per your lordship's.
30.
Lordship.
Oblige, your lordship.
Okay.
67.
Lordship. In this case, lordship, your lordship has already heard the matter at length, lordship. The fact is, the case is, my lord, the petitioner, my lord, joined, my lord, in service as Arabic teacher on, my lord, 15/8/19. My lord, the petitioner is retiring on, my lord, 31st of August, so 1st of August, lordship. My lord, he wants my justice before at least his retirement, lordship. My lord, it was listed by order, lordship. My lord, only one point, my lord, lordship adjourned the matter, lordship. Now, the petitioner, my lord, joined on 15/8/1998 as Arabic teacher, lordship. The respondent number 5, lordship. Respondent number 5, my lord, joined, my lord, on 17/12/1998.
who appears for the private respondents, 5 and 6? Yeah, for 5 and 6.
My lord.
Both.
My lord, he has admitted everything, lordship. The apartments of the petitioner, my lord, has been admitted.
To the appeal authority, Lordship, as per section 14 of the Act.
Yes, ma'am.
Yes, that is there, my lord. That is there, lordship. Now, my lord, I am coming to that, lordship. Only, my lord, grievance is, lordship, the after, my lord, provincialization of the compulsory 3 subjects, my lord. One, my lord, for maths, 1 mathematics, 1 for social science, and 1 for languages, lordship. the other subjects lordship, if the enrollment covers lordship, enrollment covers my lord, the enrollment was my lord 151 lordship. Now, kindly see the application lordship at page 21, provincialization application submitted by the headmaster of the school lordship. At page 25, 25 lordship.
Yes.
I'm sorry, lordship. It is 29 lordship. This is submitted by the headmaster lordship, page 29, annexure 8. The particulars of the application lordship, particulars of the staff's lordship, that is at page 30.
Yes.
Page 30, one is Omar Ali Ahmed, headmaster. Second is assistant teacher Lal Mahmood. Nadirul Islam, he is the respondent number 6 lordship. Assistant, his date of joining is 1/2/2007. My lord, next is lordship, my lord Azizur Rahman, the petitioner lordship. The petitioner's date of joining is 10/8/1998. 10/8/1998, my lord. The respondent number 5 lordship. Respondent number 5 is Abu Tahir, 80, Hindi, 17/12/1998. It is admitted by the respondent number 5 lordship by filing affidavit lordship. My lord, his date of joining is 17/12/1998. But the DLC, kindly see lordship, the DLC recommendation lordship. In the DLC recommendation, this fact was misrepresented lordship. That is at page 37. My lord, page 37, my lord, that is serial number 1. My lord, staff is at column, my lord, 13. My lord, Umar Ali, Lal Mahmood, Nadirul Islam, respondent number 6, his date of joining 1/2/2007. Abu Tahir lordship, 17/12/1990 lordship. This was misrepresented lordship. Because of this lordship, his provincialization was done lordship. Now, after this, my lord, DLC recommendation lordship, I submitted application before the appeal before the director, my lord, elementary education lordship. That is kindly see lordship the affidavit in reply filed, my lord, by the petitioner lordship. In affidavit in reply, my lord, I have annexed that my lord appeal lordship.
Appeal is pending.
My lord, appeal is pending. My lord, appeal was filed in way back in 2019 lordship. Ignoring that appeal lordship, the provincialization was done in 2021 lordship. Kindly see lordship that
Where's your reply affidavit?
yes, like a reply affidavit lordship. That was on
When did you file it?
my lord, it was last Friday. Before last Friday, it was filed. So date to then. In the month of June lordship, it was filed.
879.
Page, my lord. 82 is the appeal lordship.
I don't have your reply affidavit. That is the problem. I have only up to page 75.
In the month of
That is the annexure M of the affidavit in opposition of the respondents 5 and 6.
the copy is with me, lordship.
Okay, we'll get it. We'll have it on day after tomorrow.
My lord, on 1st of August,
I know.
my lord, as top of the list, lordship may be listed.
That you can update it. But Mr. MS Ahmed, learned counsel for the petitioner, submits that he has filed an additional affidavit in reply to the counter filed by the
To the respondent number, lordship, 2.
to the counter filed by the respondent number 2. Please to verify and place the same on record and list the matter again on 24th.
My lord, top of the list or at 2 lordship.
That you can update it.
If time does not permit lordship. All right, lordship.
May yeah, let's say affidavit is filed. So matter may come for admission hearing, let's say on a hearing day.
You file your reply.
Yes, Lord. 6th of August or 12th of August. Lord. A hearing on a hearing day. Lord.
When?
6th of August or 12th of August.
Gift
Your
date
6th of August, Lords.
on request made by department. Matter of 6th of August.
Obliged.
69.
My lord, matter is under process, my lord. I have not received any complete instruction whether the area salary was paid or not. So, my lord, some time they are not. Matter is under
Mr. Ayalam, the council for the division. On request made by Ms. N. Fukal, the standing council, elementary education department. How much time?
2 weeks.
Two.
My lord, date may be kindly fixed.
2 weeks time is allowed to enable her to receive instructions.
Process to
এইগুলো তো মনে নেই।
Please don't. 7th August.
Right.
It's a question of where salary that has been submitted to the secretary already.
There is some process, my lord. So,
There's a process.
yes.
That was in June, it was already done. See if
72.
May appear, last occasion, my lord, the inquiry was directed and submit the report, my lord.
I have received the inquiry report, my lord. As per my instruction, my lord, as per Honorable Court order dated 14/6/2024, hearing is conducted, hearing was conducted, my lord. And after hearing, my lord, all the relevant document sent to the government for consideration, my lord. The petition, my lord. So now is pending before the government, my lord, for final decision, my lord.
what is it?
This is communication, madam. Next page is. Madam. Nine zero 85 11 59 44.
Okay, heard, Mr.
HL Ashkar.
H.L. Laskar and the counsel for the petitioner, Mr.
Be taluted.
P. Dalukta and standing counsel,
Elementary education.
elementary education subjects. That the hearing has been conducted by the hearing committee,
My lord,
huh? That the hearing was, that the hearing was conducted on
28/6.
on 28/6/2024. And the report of the hearing has been submitted to the government on 27/2024 for necessary orders. Stop. He therefore prays for how much time? 2 weeks.
Right.
2 weeks time. to enable
Or
him to
4 weeks,
receive
my lord,
this.
that the government decide to. In the
4 weeks will be stretching too long. We will press for 3 weeks.
3 weeks,
time
ma'am.
to enable him to receive. Please.
Date may be fixed, my lord.
16th August.
Most probably.
77, 78.
May it please your lordship. My lord will kindly produce the last order dated 17/5/24, my lord.
Yes.
My lord, the higher education department is yet to file their affidavit. My lord, since 1.5 years, they have been taking time to file affidavit, my lord. Some observation at least, my lord.
Yes, Bhuyan.
2 weeks time.
Last chance. Make sure you file it, otherwise.
Then does it 3
Hurt Mr.
K. Mohammed.
K. Mohammed, Learning Council. Mr. S. Bhuyan, then Standing Council Higher Education. Is allowed 3 weeks time. As last chance. To enabling the file contract. Please. 3 weeks.
Oblige.
79.
For so many cases today.
Lordship, as per last order, instruction was directed to obtain your lordship.
Secondary education, who appears? Mushari.
Lordship, here the main party is Seba, your lordship, because the prayer here is not to allow the continuation of the school in the land in question, your lordship. And also directing the respondents to cancel the recognition of the South Point High School. So here, your lordship, Seba will be the right authority, your lordship.
It is respondent number 3, your lordship.
And lordship, in the cause list, your lordship, Standing Council Seba is not reflected, your lordship. Lordship, here we have no role, your lordship, secondary education.
Hurt Mr.
Elmo.
L. Mohan, Learning Council for petitioner. None appears for the Seba. Stop. MSD Mushari, Learning Standing Council appears for the Secondary Education Department. And Mr. Gialam, Learning Council appears for the response number 5. Please the matter after 2 weeks. Registers directly to reflect the name of the Learning Standing Council, Seba.
Seba.
So the date may be fixed.
12 August.
Obliged, your lordship.
81.
May I please, your lordship? My lord, the petitioner before your lordship is my lord, senior assistant of the inspector of school Nalbari, my lord. He was allegedly, my lord, overstayed in service for 26 months, my lord. Page 15 is the impugn order, my lord. Page 15, my lord.
Oh.
Annexure 3. It is, my lord, in the, my lord, after my lord, small paragraph, my lord, 1, 2, 3, 4, 5, my lord. Whereas he done an excess amount of rupees so and so for 26 extra months, my lord. His date of birth is put in the my lord, service book on 1st July 1962. According to them, my lord, it ought to have been, my lord, 1st July 1959.
in the second, my lord, writ petition, 81 item, this order is stayed by this honorable court. Then I filed this present current, my lord, writ petition, paying for, my lord, provisional pension. According to this honorable court, my lord, granted provisional pension.
Counter has come.
Lordship, we have filed.
I have not received copy. When filed?
Affidavit in opposition has been filed.
Not that.
Lordship, we have filed.
Unless you're given a copy, how can they file it?
Because in item number 80, we have filed, your lordship.
Yeah, item 80, you have received a copy on 10/1/2024. Have you got a copy? You have an extra copy?
Lordship, right now, we don't have, lordship, I'll give.
Furnish him an extra.
Lordship, I will. Tomorrow I'll give it.
It is respondent number 6, my lord.
Huh.
Yeah, it's filed by the inspector of schools. He has a copy, your lord.
My lord, I've got one.
Where's your service book?
My lord, service book along with them.
Service book, your lordship, because his allegation against him is that he had tampered with his date of birth, your lordship. So the service book entire record is with the police because we had filed lodged an FIR and all the documents were seized, your lordship, and he has been charge sheeted also. And it is also for that reason, lordship, we are unable to give him all the pensionary benefits. Otherwise, he has been getting the provisional pension, your lordship.
Admittedly, my lord, in the service book, under their seal and signature, date of birth is written, my lord, 1962, my lord. So, my lord, it is the record in their custody, my lord. The petitioner, my lord, is not able to, my lord, manipulate such date of birth.
Lordship, it is now that it has been with the police. Earlier it was with him, your lordship, and that is why he was able to tamper with the date of birth, your lordship. And we had called for the original record from the board, your lordship, and there they have given the report that his original date of birth should be 62. According to him, it is 59. And he had overstayed for 2 years.
According to my lord service book, it is given, my lord, 1962. Actual date of birth is 1959. My lord.
You're claiming 1959?
No, it is actually, my lord, genuinely it is 1959. But in the service book, my lord, somehow, my lord, it is written date of birth is 1962, my lord. And it is under the seal and signature of the inspector of school, my lord. This page is, my lord, fill up.
No, are you admitting that your date of birth is 1959?
My lord, 59, my lord.
59?
59.
Then you purposely stayed back, overstayed, is it?
No, lord, this is their mistake, my lord.
No, how can it be their mistake when you know that your date of birth is 1959?
No, because
you should have said that my date of
my
birth
lord,
is
my
1959.
lord,
I have to retire
my
back
lord,
to
this
that.
issue,
Let me go.
yes, my lord, this issue is, my lord, resolved by this honorable court and all the honorable Supreme Court, my lord. There, my lord, because, my lord, when I joined the service, my lord, then, my lord, my service was, my lord, 58 years. Then they made, without noticing me, 59. Then it is made, my lord, 60 years, my lord. Never, my lord, in the advertisement, in my appointment letter, it is written, my lord, my exact date of birth, my lord. So far, my lord, as per law provides that, so far, my lord, notice is not received from the authority when I will retirement, I will not know.
Retirement is based
And
on
this
the date
is,
of birth.
this is,
That Supreme Court ruling, that is a different issue.
I have annexed, my lord, for ready reference one judgment, my lord.
That's
Because, my lord, as per rule, my lord, they are to, my lord, issue notice. Then I will, my lord, retire, my lord. And in the, my lord, service, importantly, my lord, it is indirectly, my lord, in the earlier, my lord, matriculation certificate, birth date is, my lord, indirectly written. My lord, therefore, perhaps they have miscalculated, therefore, my lord, date of birth is wrongly written.
Have you filed your affidavit in the other petition?
Lordship, in the other writ petition, Lordship, because here we had already given him
Because
the.
these are two different councils.
My lord, I am also there, my lord. I have
You
submitted.
also
for-
the other petition.
Yes, my lord, I have submitted, my lord.
Your Vakula number.
My lord.
This is with regard to.
Lordship, this
80,
is
my lord.
81.
81 is.
81 is to quash the communication dated 29/2021, where he was asked to give the excess amount.
Excess amount order I have challenged, my lord.
So it's
And
same,
it is stayed, my lord. And now, my lord, this present 80 item, my lord, I prayed for pension, therefore, my lord, provisional pension is granted.
Okay. So when shall we have it?
As per his convenience, because we have filed our counter, your lordship.
So this one counter will cover the other one.
Lordship, because
Next week, my lord, maybe fixed, my lord, I will submit in the meantime. reply.
Request by parties. This on second August.
obliged.
My lord, one important, my lord, thing, my lord, their service book is necessary, my lord, because
It is with the police. How can they?
my lord, they may take, my lord, one Xerox copy at least, my lord. It is their property, my lord. Because, my lord, this is very important, my lord. There is, my lord, written.
Seized by the DC, your lord.
Seized by the deputy
No,
commissioner.
otherwise, my lord, only it is,
Those in police case, that was seized by the deputy commissioner, Lord.
my lord,
Or the seized by the
Yes.
deputy commissioner.
yes, my lord. Because without, my lord, having, my lord, glimpse of this service book, my lord, your lordship will consider, my lord.
You try to get the photocopy.
Yes, my lord.
Lordship, I'll try, lord.
Okay.
Kindly, my lord, lordship may observe, my lord, they are.
No, that should not be observed.
No, it will not.
Because, my lord, this is their property, my lord, they can take one Xerox copy, my lord, from the police also.
Let it not be on record, lordship, I'll
And
try.
it is charge sheeted, my lord, they must take certificate copy also, my lord.
You can get a copy. There's no.
Yes, my lord.
It to DC, government will property protection. Let him.
Obliged.
Deep problem.
Actually, may I pray for a date in item number 91 for 93, your lordship? We have not been paid our salary, lordship. Lordship.